Ooh. Okay. I think the goal is I need to find a way to take our notes and our reading and our disagreements and turn this into like a 15-minute YouTube video. How do we do it? You're interested in going on Bill Maher's show, Random Club. I'm one of his interns. Sure thing, Barracuda. Okay, just as a heads up, if you were in the stream disagreements chat and I drag you up and you don't have a disagreement, you're like, oh, I just want to come up and talk to you and say, hi, I love you, blah, blah. I'm perma-banning you from my Discord server, just as a heads up. Okay, good luck. All right, what do you want? Alex Davies, you're up.
Hello? Can you hear me?
Loud and clear. What do you want?
Yes. Oh, Jesus. Yeah. No nickname. Right. Sorry, I'm just muting stream. Right. I feel like I'm going crazy. There is, like, what?
You're not even
there is
American.
No special,
Why the fuck are you, why are you, what do you even care? Oh my God. Sorry, go ahead.
Well, quite, okay. It's not just America that this affects with Trump and all this freaking ruling.
Yeah. Go ahead.
Anyway, there is no difference between absolute
Wait,
like,
did you just come in
immunity
to agree
versus-
with me? Is this a disagreement or?
I believe so. I do. Do you not think there?
Are you about to say that by the way that Roberts wrote the opinion, it doesn't seem like there's basically any daylight whatsoever between what absolute immunity is given to versus what presumptive immunity will turn into absolute immunity for? Is that what you're going to say?
Possibly.
Yes, I agree with you.
I'm
It's
not
bullshit.
sure.
Yes.
Okay.
Yeah.
All right. Well, bye then.
Be careful. Bye.
All right.
Gray, you're up. What do you want?
Dated back to like the fuck ups that we did in the past.
True.
But-
okay, true. Yes, you're talking to yourself. Hello?
Like bad reputation.
Nice. Okay.
Thing.
Yeah, you keep talking to yourself. No Limit, you're up. What's up?
What?
Hello? Hello? No Limit.
What?
Hello?
Hello. What the fuck are you?
Who am I?
Yes.
I'm the
Are
guy
you
that
the
runs
one
this
I was
fucking
talking
server,
to,
you
or-
fucking
or-
retard. What are you doing in my server? You don't even know who the fuck I am.
What? I don't know. Who is it?
New head mod. Stop busting. You're up.
Hello.
Hello.
How you doing, my friend? I just have a few questions.
Go for it.
Regarding last Thursday's debate, I know you went on Piers Morgan, and I know you discussed with them, and there was a 4-person panel, and that's fucking annoying. But what is your assessment, your layman's assessment of Biden's current cognitive state?
Probably pretty fucked.
Okay. Now, obviously, with the current realities, that we have open land war in Europe that we're deeply implicated in, and it could honestly break out with direct involvement to us at any moment. Who do you think is calling the shots in regards to that if there's like sundowning occurring on like a daily basis?
Probably Biden and his generals, the same as it would be for any president. Given that Donald Trump couldn't find half the countries on the map that are implicated in current conflict, I don't know if I would trust him any more than like a random fucking retard.
No.
Okay.
I'm not voting for that guy. That's not, no.
Okay.
My concern legitimately is what is the chain of command? I feel like we as the public have a certain, like, I feel like it's owed to us that we should understand the current military chain of command given what we now all understand to be Biden's current cognitive state, regardless of the consequences of the election, because everything is so critical.
Okay.
Do you have any?
What are you
thoughts about that?
suggesting?
Like,
I don't
do you
know.
have any-
If you want, you can elect him and then toss him, or maybe he'll step down after he's elected, and then we'll get a different person, Kamala, I guess, or whatever.
Well, no, not even that. Like he can like.
What are you
Like, I
suggesting?
feel
What's
like
your
it should
suggestion?
be-
What is your suggestion?
that there should be some sort of disclosure as to if he has been in this state for a certain period of time, how have decisions been made, and I feel like we need to know who's making them.
Why? We've never had
Because
that insight into presidential decisions ever in the history of all of the office. So why would we get them now?
Well, this is also a uniquely unprecedented position, considering
then
that we
pass
have
a
an
law
active
in Congress
global
to make it
conflict
so that
brewing.
disclosure is necessary.
Yeah, I support that
Okay. Good luck.
more generally. All right. So, yeah.
Ivan, you're up.
Hello? 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 Fuck.
Yep.
Hello? Hello?
What's up? Hello.
Okay, sorry. So first... Okay, hold on, wait a second. I got the stream going, it's kind of fucking up, my bad. So I was going to say that implementing a new way to add votes to a U.S. ballot is blatantly altering the outcome of the election. When they used the mail-in ballots in the 2016 election, I feel like that was just straight up altering the outcome of the election.
Okay, well, every single court disagreed with you, and most of those changes were done by and approved by the state legislature. So the states also disagree with you. So at the end of the day, who the fuck cares what you think?
Okay, wait. I'm not even saying unfairly. I'm just saying that it did alter the outcome of the election. That's all.
What do you? How do you alter the outcome of the election by giving people a different way to vote or mailing out ballots? How?
Well, the only time it was ever used was during wartime. All right, and back then, verifying identities was super easy. Now you cannot verify anybody's identity, even if you had like a million fucking.
Okay, so but by your definition, every single thing that changes any part of the election process outcomes the alternate or like alters the outcome of the election.
Significantly alters the outcome of the election.
Okay, well, those were the choices for the state legislatures to make. They made those choices. They approved them. They adhered, in all cases, basically to the state constitution. So what?
I'm just saying they significantly. Would you not disagree that they significantly altered the outcome of the election? Not unfairly, just they significantly altered the outcome of the election.
Probably. Like giving people different ways to vote probably changes the composition of voters and everything. Sure.
Okay. So we're gonna. Also have another thing. You're gonna be mad at this one. You're arguing that a peaceful call to protest and providing security is calling for an insurrection.
I'm not, but okay.
All right, whatever. That's it. Thanks. Bye.
Okay. Tea Party enthusiast.
Oh, hello?
Hello.
Oh, I think I just wanted to talk about our disagreement on that. Just, how Canada is a better country than the United States, because yours is going down the toilet. That's really all I wanted to talk about.
Well, if we go down the toilet, we're just lowering ourselves to your level.
I guess so. Anyway, have a good night, bud.
Permaband. Steve, you're up.
Yo.
What do you got?
Wait, one second. My audio is not working.
How can it be so hard? It's just Discord.
No, it's such a good opportunity. God damn it. Well, drag me back, please. Please drag me back.
Hello.
Hello.
Well, okay, what do you want?
Trump's gonna win.
We got you just permaband. I don't know. Good luck. Daypick, what's up?
Yo, what's up, dude? How's it going?
Hello.
Question. What do you think about okay, I'm sure you've heard of the term, Mr. Cultural imperialism, yeah?
I've heard the term, yeah.
All right, cool. So I'm starting to, I just moved off to college in the big city, dude. I'm starting to realize, like,
What is the
a
disagreement?
lot of,
Wait, what is the disagreement?
oh,
here?
okay. What was this agreement? Cultural imperialism, good or bad?
It just is. It can be good. It can be bad. I guess it depends on what kind of culture you export.
Okay, that's fair. Right, never mind. Okay.
Okay. Are there conservative streamers for me to argue with? Find me conservatives on Twitter. Okay, what do you want? Zetsui, you're
What?
here. I've brought you in.
I was not in the disagreement thing, but I do have a
Okay, I
disagreement.
brought you up anyway. What's up?
So when it comes to the argument saying like that, because he has immunity, the president has immunity to civil suit. Do you buy the dissenting opinion saying how that's different and should be? It's like
Absolutely,
like,
yes.
how so? Would you mind giving your thoughts on it?
Yeah, it's in two ways. It is majorly different in ways that cuts across the majority opinion. The first way is that civil litigation is incredibly easy to launch. So the threat of vexatious litigation in a civil sense is very, very, very high. You can be inundated with it. Anybody can launch it for any fucking reason. That's one part, whereas criminal litigation is a much higher threshold. And there are a lot more ways out of criminal litigation. That's part one. And then the second part is I don't know how much interest the public has in civil litigation. The state doesn't have a big interest in civil litigation. I think that the public and the state have a large interest in criminal statutes. And the fact that you're going to release somebody from any obligations under criminal statutes is a really, really, really big deal. Way larger of a deal than releasing somebody from civil damages suits.
So when it comes to civil damages, couldn't they just create a barrier in the same sense, saying like you can dismiss it quickly, like there's a quick way out, but if we use the example like the whole SEAL Team 6 thing, so if someone, or if let's say he intentionally uses his power, does the whole in Minecraft or in my official capacity, and does something that causes you damage, why would he be able to avoid any like civil litigation? So like I can get you for a wrongful death suit, I can get you for criminal, but for some reason you should be barred from civil. Like, is there a reason why? Like, so it goes, we can put you in prison, but even though he intentionally killed someone of yours and you were totally owed money, you get nothing because we decided to give blanket immunity. Why would you give blanket for it?
As part of a criminal penalty, can you be forced to pay restitution to victims, or does it always happen in a follow-up civil suit?
Not sure. I haven't run into that. I'm more saying just saying.
I mean, like if you wanted to, I would either carve out a special rule here, or I would just say, well, get fucked, I guess. I don't know if the public has the same interest in having people who's had family members killed be paid money as we do in enforcing rules around murder. I mean, like it would suck, but.
Do you think the fears, like from Sotomayor's dissent, do you think those fears are legitimate? The whole SEAL Team 6 being used to kill political opponents?
Yeah, absolutely.
You think there's a chance it can actually happen?
Well, I mean, by interpretation of the Constitution now, apparently, I mean, but definitionally it can happen, right?
Has that already happened? So in regards to civil, has that happened? Because I mean, right now they have complete immunity. Has it been abused by presidents, including Trump? Has it been abused to like avoid, to do civil damages to people and then just kind of laugh it off? Because there are plenty of cases that are only there's no criminal liability. Because I mean, I worked in civil. Like, there's no criminal.
I would say that.
Punitive.
Well, the difference. I would say no. That probably hasn't happened. But there is a strong like mens rea element to criminal charges that is totally absent in civil charges, right? So when you ask me, if you let's say you were to ask the question, do you think that somebody has like intentionally tried to commit a crime here? That's like a legal question that can be like referred to a judge and jury, right? That a jury can determine that. But if you ask me, like, was there a legitimate civil suit to be had here? I mean, the answer is like always yes. Anybody can sue anybody at any point in time for almost anything, right?
Yeah, but I'm more saying like, could the president not then take like violate contracts, not adhere to like so basically break any civil situation and profit from it and get away with it, like and that they'd be fully immune to it. You couldn't.
Oh,
get
like in a civil sense. I mean, theoretically, So theoretically, that could be a concern, but shockingly, in Fitzgerald, they had developed a test for that. I believe that there was a test that weighed the public interest against a particular civil action. I think in order to determine if the civil action could proceed, and in 99.99% of cases, the answer would just be no. But I believe in Fitzgerald, I think there was a test for that in public interest. I can look that up real quick if you want me to.
Yeah, I would, because at least I didn't read the thing, but in the actual opinion, it seemed to be saying absolute immunity from civil damages.
Okay, hold on. Fitzgerald, Nixon, Supreme Court.
Yeah, because it led the court to recognize absolute presidential immunity from civil damage liability.
Oh, wait, hold on. Let me read that executive first. You're saying that...
in the opinion, it'd be at page 3 is where it references, where it refers to it as an absolute. 3 halfway down.
Okay, hold on. I'm just reading.
Fitzgerald, I don't know.
Okay, so petitioner, as a former president of the United States, is entitled to absolute immunity from damages liability predicated on his official acts. So
Yes.
it seems like that absolute immunity wouldn't extend to him just violating a contract, right? Although there is no blanket recognition of absolute immunity for all federal executive officials from liability for civil damage resulting from constitutional violations, certain officials, such as judges and prosecutors, because of the special nature of their responsibilities, require absolute exemption from liability. But so the determination of the immunity of particular officials is guided by the Constitution, federal sector law. The president's absolute immunity is a functionally mandated incident of his unique office, rooted in the constitutional tradition of the separation of powers, supported by national history, because of the single points of the president's duties. Diversion of energies by concern with private lawsuits would raise unique risks to the effective function of the government. Separation of powers doctrine does not bar every exercise of jurisdiction of the president. A court, before exercising jurisdiction, must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. The exercise of jurisdiction is not warranted in the case of merely private suits for damages based on a president's official acts. And then C, the president's absolute immunity extends to all acts within the outer perimeter of his duties of office. A rule of absolute immunity for the president does not leave the nation without sufficient protection against his misconduct. There remains the constitutional remedy of impeachment, as well as the deterrent effects of constant scrutiny by the press and vigilant oversight by Congress. Other incentives to avoid misconduct may include a desire to earn re-election, the need to maintain prestige as an element of presidential influence, and a president's traditional concern for his historical statute. Okay, so it sounds like, so the final holding here was for official acts as president. He has immunity from civil lawsuits, yeah.
Yeah, and so, but isn't like the whole fear of saying like he's just going to say in my official capacity, and that gets him free pass to like use SEAL Team 6 to kill people, or even like, and just as long as he says the words basically in Minecraft at the end, he gets away with it. Wouldn't it work here as well?
It doesn't sound like in this case in Fitzgerald, it doesn't sound like they made those official acts quite as broad as president.
Now, because the thing is where it says
they might have made them
as in your official acts.
Yeah, they might have broadened it, but if they did, it would be confusing to me why Roberts would have never cited to that broadening. It sounds like they're only talking about official acts here.
That was probably my biggest complaint with the majorities. I feel like they should have addressed the dissent a lot better in terms of like their doomsday scenarios. Because if they're trying to say, because then I've seen like articles saying like, no, you can't use SEAL Team 6. Shouldn't they have addressed those hypotheticals to explain why theirs didn't broaden it that far?
Yeah, and to be clear, when you said
I would love to have seen that,
you wish they would have done a better job. They did no job. They essentially didn't. They didn't address any of the, in my opinion, the huge issues brought up by the dissent. The biggest one being the fact that I don't think you can just carry over anything we would say for civil stuff, just carry that over easily to criminal stuff. I think that that's a little ridiculous, in my opinion. I think a separate set of arguments need to be made. Maybe you could reference the arguments for the civil stuff, but I think criminal stuff is of a different nature.
Do you think, based on their opinion, so like, because I noticed again, this we use the SEAL Team 6 and say like controlling the military, but could you just say like under the pardon power and then start like he could just start stabbing people randomly and just say I do this under my pardon power? Do you believe that this would cover it? Because he said the in my pardon power, therefore nothing can be questioned. His motives is like nothing can be questioned. Thus, even though it has no rational relation to the action, because he said, because of my pardon powers, I do this, it would get away under this ruling.
It seems, as stupid as that sounds, that it seems that by letter of what Roberts has written, like the text that he writes in his opinion seems to support that idea. For instance, the President of the United States has no authority to order the DOJ to send false letters claiming that they found evidence for something. The President has no power to do that anywhere. However, because the president threatened to fire the acting attorney general if he didn't do that, that is an absolutely immune from all criminal investigation or judicial review act, according to Roberts. And he explicitly called that act out and excused it, even though that is not a core power or function of the president of the United States.
So in that scenario, would you say, like the one you just gave, he shouldn't be able to fire, like that the person is now immune from firing, basically, by the president? So even though the president's his boss...
No, I wouldn't question the power of him to fire the person. I think the president, that is a core function, I believe, of the president, is his right to appoint his officers. However, like, should he be able to sneak in a little itty-bitty crime with the appointment? I don't think so. I don't think he has that right. I don't think that's granted in the Constitution, and I don't think that should be beyond review.
In terms of like, because they also reference pardon power. So let's say again, for a pardon power, let's say he's about to pardon someone, but he goes, hey, this person's black. I'm not going to pardon a black guy. And so he refuses to pardon the black person. Like solely, the only reason he was about to do it, but he doesn't do it because the guy's black. Mm-hmm. Would that be something you go, he's violated, it's unconstitutional to make discrimination? Would you be able to get him, do you believe there should be any sort of like a recourse against that?
I don't think, I mean, discrimination is not illegal in the United States. I think it's only it's like an additive thing, or it's like a requirement in some cases, right? Like if I'm an employer, and I want to hire somebody, there's regulations around that where I can't discriminate against protected classes. But if I like have a group of friends and we're like hanging out, and I like am inviting friends to hang out with me, and I say no black people allowed, I'm allowed to do that. So I don't know if like the president exercising his pardon power, I don't think there are any that doesn't apply to like class, or there are no protected classes there.
So even if like they said like if all pardons were basically denied to all black people, you don't believe that they've been there'd be no violation under the Equal Protections Clause, that like laws aren't being misapplied if only white people can get pardoned, or if even like if he just pardoned all white people but refused to do any black people, that wouldn't be an Equal Protections violation in your mind.
I would have to read now. I have to read all the laws.
Like I said, I'm not trying to hold you like
no, that's fine. I would see the exact text of the Equal Protections Clause of the 14th Amendment, right?
Yeah, and what I'm getting at is kind of saying like the limitations. At least if I'm being charitable, I'm trying to get at what I think they're saying is that if you can come after him, can you limit and say control the president but via law? So if you say like, okay, it's not illegal to not do what Congress tells you to do. You can use your powers, but if we make a law, we're coming after you the second you get out of office. So
well, but like the thing is that you can't make illegal a power delegated to the executive. Congress doesn't have the ability to pass a law against that, right?
But if that means that like but then how can you do something illegal under your core power? So if they can't limit it in any way,
because the president, none of the core powers of the presidency empower him to commit crimes. Like nothing in the pardon power says that you can like take a bribe. Bribery is considered one of the high crimes, misdemeanors. Bribery, I think bribery is part of that, right? I think bribery is spelled out in the official like original Constitution without even an amendment. But let's say for instance, like the president goes up to people, the president gets on TV and he's like, listen up, Americans, fellow Americans, I am going to begin pardoning people. I will pardon you if you promise to pay me $1 million, right? That the pardon, that's a core power of the president. That is conclusive and preclusively the president's. He can do that, even though he's essentially like asking for bribes to pardon people. That would be beyond judicial review, I believe, by the text written by Roberts. I don't know how you could ever review that, given what he said about that being a core presidential power.
Well, say it would be that getting bribed isn't your core power.
What?
Getting bribed isn't a core power.
Correct.
In the same sense,
but you can't talk about the bribe. You could say, well, look, the president received all this money, and we think that was illegal. And you go, why is it illegal to get money? Well, because he was bribed. Bribed for what? Well, because he absolute immunity. It's the core power of the president. You can't even talk about the pardon. So you need to find a way to bring this up in court without mentioning the pardon part.
That's what I'm trying to because that was the last part, the part that Amy Coney Barrett disagreed with.
Yeah, because Roberts has said that that absolute immunity even applies to submission to evidence. It can't even be used as an evidentiary thing.
Yeah. So in terms of what do you think they were trying to get? So whether they're saying the text didn't get there, do you have an idea of what, like if you could say, again, charitable, not saying the text, but the idea of what they were trying to get at, do you think you have an idea of do you think they were trying to just go like, fuck you, Trump wins forever? Or do you think there was like something that they were actually hitting?
I truly have no idea. I truly don't understand. I could steelman Amy's position. As much as I might disagree with it, I think Barrett has a legitimate argument that there probably should be some core powers of the president that are beyond judicial review. It's probably fair. There's probably some core things, arguably. But to extend that to the outer perimeter and beyond, really, in a way that Trump's attorneys weren't even asking for, and then to not even give a test for it, I don't understand at all. I don't get the legal argument at all for it.
What it seems like getting, at least from my perspective, is that it's there's an issue where like I can't get you for the crime, but if I don't like what you did, I can bring it up as evidence and just show it to the jury and give them a wink, and then they'll like find you guilty. There was a case had to do with a murder trial where basically the guy was accused of killing his entire family. The reality was it wasn't really possible. Like he was at a basketball game the entire time, but like no one could say that they stared at him the entire time. And it turns out he was cheating on his wife with like several people.
Sure, but there's a rule there. The rule there is evidentiary, right? That can't be submitted as evidence in a court. If
it was.
He was
found guilty several times in a row. Like they're saying that like if you can get like go.
Wait, but why was the prosecution allowed to bring that up if it wasn't relevant to whatever the trial was?
Motive. You're saying that like, oh, he was trying to get rid of his family so he could be with one of his the other people, what are they called? Mistresses, I guess. The people he's cheating on. What was what I recall what it was. And it was challenged. I think it was overturned eventually after like 4 retryings, something like that.
I guess
But,
like if you're,
he was
I just
convicted and put in prison for like decades over it.
I don't understand. Can you give me an example of how this would play in a presidential concept or in our context? Sorry.
Let's go with let's go with the one with like the whole Stormy Daniels thing. So that in the court, they detailed the details of the sex between Stormy Daniels and Trump. That the entirety of the actual act itself isn't really relevant to whether a document said something or not. But if you don't like someone who cheats on someone and you can bring that into a case, suddenly you can get someone to convict them of pretty much anything because they don't like that. And so especially for a president, if you have an aggressive prosecutor who goes, I think I can attach it, and all I need to do is get a jury who doesn't like the person, and they'll just convict him because I say so. Because all I have to do is bring in the thing that you don't like that he did.
Sure. For
and
federal
then I can
court,
just attach it to anything.
I understand. For federal court, they don't like cameras. Is there a transcript of those? Was this challenged in pretrial for submission of evidence?
In which one? Are you about the Trump one or the
Stormy Daniels one? You're saying that in the New York case, they were going over explicit sexual acts?
Yeah, she detailed it.
Okay, then
Like, so I think,
what was this challenged by the defense as like, why is this allowed to be submitted in evidence? What did the judge say to that?
They made multiple objections. I think there's a problem you run into is that if you object and you keep getting sustained and they're overruled.
No, wait. I'm not talking about like during the trial. I'm saying like for pretrial, don't you argue over what's allowed to be introduced into evidence and stuff like character evidence, and that's the stuff that people fight over. I saw in the Rittenhouse trial, they'll fight over like, can I submit this? Can I talk about this? Can I bring this up in front of a jury? And then you'll fight over it in front of the judge, and the judge will decide yes or no. Like, I can't
recall the specific pretrial. The judge actually said afterwards he wished that they had objected more to it, basically, because they're saying like even he goes, yeah, a lot of that stuff shouldn't come in, and they didn't object enough. But I'd have to actually look through the exact of it because there's a balancing act between objecting every single time, but if you keep getting overruled, it makes you look terrible. But either way, the fact is the prosecution was able to get in sex facts basically, and if the defense won't object to it, you're still introducing like that. The prosecution's able to get in a lot of irrelevant information. Like it is.
Well, yeah, but I mean, that's on the defense at that point. Like you have to, I mean, that's part of your defense that you should probably argue pretrial. You know what evidence is going to be brought up in court, right? It's not a movie. They don't like, oh, here's our surprise witness or here's our surprise fact that we're now submitting into evidence in the middle of the trial.
No,
like you should know all of that ahead of time, no?
You can ask questions that are not relevant, but can lead to to probative. Like, so if you go like, this one isn't, but it's going to get me there. That's why they go like, where if you watch like Law and Order, it's like, you're on thin ice. I'll let this keep going, but I'm going to put the brakes on if you don't get to your point soon. And so if you, and again, like I said, like where that was the argument, again, it depends on who you believe, but if them saying,
sure, but there's going to be big subjects that they don't want brought up at all, and a defense should be cognizant of that, right? Like, let's say that I'm charged with like murdering my fucking wife, okay?
Yes.
And let's say that I'm also like a prolific, like serial gay sex, visitor or some bullshit, right? And the prosecution. Or no, as the defense, I know that the prosecution is going to want to bring up the fact that I go to a fuck ton of gay clubs and I hate women. I know they're going to want to bring that up, right? But you better believe that my lawyer, I'm going to tell him, the lawyer's going to tell me because he'll know more than me. The lawyer say, yeah, obviously, pre-trial, we're going to go before the judge. We're going to challenge, this being submitted in evidence. The character evidence here, we don't believe is admissible because of whatever bullshit rules of evidence you would run through it, and you would fight in front of a judge about that. You wouldn't sit there in the courtroom and then like your eyes open. It's like, oh shit, they're bringing up the fact that I go to gay clubs and I hate women. Object. Like, no, you fucked up. You should have like fought against that beforehand, no? Like that, I feel like that's something that would absolutely come up.
Yeah. So I would need to see the pretrial. It would come down to saying like, what can I like? Because you don't go through pretrial and say, give me everything you're going to ask about them, or even go, I need to read more of it. But yes.
Well, but you have to make available.
As basic as that.
You have to make available to the defense everything that you're going to be utilizing in court. No.
Correct. But I'm saying, like I said, that where you can ask questions and let them lead to, like, so you don't, every single question doesn't need to immediately be probative. It can go, this one isn't, and they'll go objection. They might say like, I'll see where this goes, but like you have to like get to a point here within like 2 questions. And so again, I need to read the text of it, but again, we're disputing based on the
sure.
But the general, what I'm trying to get at is not the again disputing on the exact point, because I haven't. I need to read more of this transcript.
I think the general response I would give you is actually one that I'm glad that I think Jackson and Sotomayor might have brought this up. Is that this sounds like a scathing indictment of our federal courts or our entire legal system if what we're saying is like, well, all of this is bullshit and people can find ways to fuck with you by like skirting a bunch of the rules. And if that's what we want to argue, then I think there's 2 huge issues where this fails. So one, is you're either arguing that this is like completely fucked and that the way that we do like rules of evidence and the motions to dismiss, that all of that is fucked for federal cases, and we recognize that, which is why we have to protect the president from it because it's so fucked, in which case you're kind of throwing the entire judiciary under the bus. Or you're saying that because of the extra special circumstances around the president, none of these federal protections are going to be good enough for him, in which case the president could be fucked by literally anything then, and it doesn't matter. Let's say
why we have it for civil, isn't it?
Huh?
Like, that's like the whole reason to wait. He's going to be fucked, so we have to give him protections. And
nope.
The reason
No. Because
civil, we haven't done that.
No. Forget civil. I'm still talking criminal. You might say that an ardent litigator that hates fucking Donald Trump, maybe in another state, maybe he brings some bullshit ass criminal charges up, and the entire jury hates him so fucking much because it's the president, he can never get a fair trial. But the criminal charges aren't related to anything he did in office. They're trying to charge him for some irrelevant shit he did in his campaign, maybe like falsifying business records, for paying a prostitute, something, right? That's all. That's bullshit though, right? But like the idea that people could be vexatious in a criminal court, if you really think it's all that bad and the federal protections are so horrible, that would apply to literally every single criminal statute. So at that point, like, your argument carries over just as equally to anything else, no?
Anything else being, what do you mean? Like
let's say that I think,
civil,
let's say Donald Trump orders a drone strike on a person, and I'm an adventurous litigator, and I want to make a name for myself. I want to take Trump to criminal court for that. And Roberts is saying, well, bro, it's Donald Trump. He can't. He's so divisive as a president, and maybe it was an important, national security reason. But like, people are going to be so, hateful of him. Like, he can't stand. No, that's absolutely immune. Okay. Well, if we think that the people are so mind fucked that they'll go after Trump no matter what, they'll ignore all the rules of evidence, they'll ignore all the procedures, they'll ignore everything. The judge and everybody's so biased against him, right? If that's the case, then maybe as soon as Trump gets out of office, maybe the prosecutor in this particular state goes, you know what? That guy that died in a car accident like 4 days ago, I bet Trump killed that dude. And now we're bringing criminal charges on you for that motherfucker. And now you're going to come to court and you're going to answer it in front of my judge to this jury of people that all also hate you because we're all incredibly biased politically. And fuck you. Now you're going down for criminal charge. Yeah. If you think the courts and the jury and everybody is so biased, I mean, then that's unavoidable, right? You're fucked no matter what there.
Yeah, no, I agree. You're saying basically that, like, if it's that fucked, then they don't even, like, the idea that I would even put any barrier would matter. Just
exactly.
Saying, like, you could literally,
they're going to abuse it no matter what.
They wouldn't even need to put in gibberish in it and just go, they'll convict him because they hate him.
Exactly.
And
which is what they're claiming, by the way. That's what Roberts is saying, because the role of the president is so divisive. People might ignore all sorts of shit because they hate him so much, right?
Do you have your notes on like that last? So when it comes to the final, like whether it can be used evidence on it, because I'm trying to find it in the actual opinion. Because I'm trying to see like exactly whether there are any limitations on it.
No.
And
not if it's an absolute immunity, and not if they fail the presumptive immunity. Basically, if it's absolute immunity, you can never be considered in any part, because the argument that Roberts makes is like, well, the entire point of the immunity is defeated. By the way, this is also a novel argument. I don't think any immunity, qualified immunity or anything, has never been used this way before. But Roberts' argument is that, like, well, hold on. If we say that he has immunity from these things, we're defeating the entire purpose of the immunity by not granting him immunity from probing as in other parts of the court system. I can try to find that exactly.
Yeah, I'm just trying to find the actual section because I can read it. Because, yeah, like I said, the biggest part that bothers me about it is that if they had, because they don't address even the concurring opinion, they don't address her either. They don't address these things that say, like, aren't these large problems? Wouldn't you at least address them and say, because if you're saying that they're wrong, you didn't address them at all. And so where I'm reading articles from like Bill Barr and stuff trying to say why the dissenting, their fears are unfounded, it would have been nice to see that in the majority's opinion. But they didn't do that. And so the problem is that I can't. Yeah, it's unbelievably frustrating if I'm being like.
Yeah, especially because he does respond to some things. Yeah.
Yeah, he responds to some and doesn't respond to others, and it's kind of weird when especially as I was just reading the other one on the Jan Sixers. I was like reading Jackson's opinion, and just like she's addressing everything. They're all even using the same analogies. They're even like going through it more. Like I'm like, this is great. This is like using great way of explaining each person's positions and why they disagree on each point. And I'm like, why the fuck isn't that here? Where I think it's the most like unbelievably important that you do it in all times, and you didn't fucking do it, which leaves these giant gaps. So the question is are these going to be filled in other cases? Because I mean, if someone tried to use SEAL Team 6 to do it, you'd challenge it and it would go to the Supreme Court because the question, it hasn't been filled in. That we don't actually have the answer to that. You could say, well, I think by the reading of it, but they didn't address it. They didn't address that specifics. They're not clear enough, and so that would have to be further analyzed after the SEAL Team 6 kills someone, basically. But because the thing is, I agree with you that if the textual reading that a lot of people are saying, I actually don't like when people saying like, oh, I can order the military so I can use SEAL Team 6. by this, if you go by the reading that everyone's talking about, it is the whole pardon. You can use the pardon power and just stab someone, and just in Minecraft suddenly works now. You can just say, in my official capacity.
Annoying thing is that Jackson explicitly, I think Sotomayor explicitly brings this up in her final paragraph, and obviously this has made its rounds in the media as well, and it was brought up first on Destiny's stream. Okay, so this has been brought up quite a bit by a few different people, including the dissenting opinion. Why wouldn't Roberts address that at all? I don't think he even makes an attempt to address that. I don't know why you wouldn't say anything about it.
Yeah, because here I just found the section and it goes, "Mentioned by jury based on generally applicable criminal laws, use of evidence about such conduct, even when indictments alleges only unofficial conduct, would thereby heighten the prospect that president's officialism may be distorted." Referring to Clinton. In dividing official from unofficial conduct, courts may not inquire into the president's motives. Such a highly intrusive inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose. Nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. Otherwise, presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its intended effect. With the above principles in mind, the court turns to the conduct alleged in the indictment. Certain allegations, such as those involving Trump's discussions with the acting attorney general, are readily categorized in light of the nature of the president's office or official relationship to the office held by that individual. Other allegations, such as those involving Trump's interaction with the vice president, state officials, blah, blah, blah. But so that this first part here, and there's more where he writes more on this, but even probing the inquiry itself is highly intrusive and would destroy the point of the immunity. Also, again, look at how little faith we have in our court system. Killing people is illegal. You can't kill people generally. You can't imprison people. You can't handcuff people. But cops do this all the time. We don't have an infinite amount of challenges from all of these, from every single time this action takes place. It doesn't happen. It's just I don't know. But the same is the same faith where you're saying that the whole SEAL Team 6 thing could actually happen. You have no faith that the dissenting opinion says this. The majority also doesn't agree with them. Doesn't go oh yeah, no, SEAL Team 6, fucking immune. Go nuts, man. Just again, say in Minecraft and do it. They didn't say all that. They didn't even cost some of the things. They even go, they redressed it or put it back to the lower courts to say, determine if this is official or unofficial. If their ruling is so broad, then couldn't they just rule? Why wouldn't they just say now, literally everything is official? As long as he's willing to say the words official, then he's good to go.
Well, because that would be ridiculous, and I think they know it. But while they haven't made it broad... Well, but they've given themselves an out where it doesn't look ridiculous by developing this crazy and wacky distinction between official and unofficial acts that they provide essentially no guidance on, right? If we are to read what they've said, by the words of what they've said that you cannot, if you're going to prosecute a particular presidential action, that prosecution must pose, quote, no dangers of intrusion on the authority and functions of the executive branch, end quote. There's not a balancing test there in public interest or state interest or anything else, or the severity of the crime. There just can be no dangers of intrusion on the authority and function, of the executive branch. That. So I don't even know. They don't even propose any sort of test. They don't even make it clear how you would even begin to sort any of this out. Roberts offers zero guidance on it. Everything is remanded to the lower courts. Things that Trump's own attorney was saying, yeah, these are probably... We understand that the conversations that he had about the electoral slates, we're not saying that this is official conduct. That would be ridiculous. And Roberts is saying, actually, you're ridiculous. All of that could be official conduct. And we're going to remand this to the lower courts to make a determination on every single action. And by the way, if any of it is determined to be official conduct, not only can you not indict on those actions, you can't even use them for evidence of other actions.
And so then if they rule them as unofficial, then back to the Supreme Court it goes, basically.
Exactly.
And go, try again. Give us more information. Because they are saying, because you can rule them as unofficial, and then... So that's one thing, is it feels like we don't actually have the whole SEAL Team 6 thing. Because if you did it, and it goes, actually, we clarify, no, this isn't official conduct. Yeah, we didn't... It goes, we didn't give enough clarity. We'll give more now. To prison you go. There's still a risk here because...
you just find something that's because he uses this conclusive and preclusive over and over again. You just find something that is exclusively within the realm of the president, that the president himself is the only one that can do that he has to do. So for instance, communicating with his officers, That's something that only a president could do. Congress isn't going to be fucking talking to the head of the CIA or the FBI. That's exclusively within the role of the president. So if the president goes to one of these people and he says, listen, I'm going to fire you unless you start mass rapes in the state of fucking Wisconsin, well, you can't even probe on that action. This is a conversation about the employment of an official officer. If there was ever a core power to the presidency, it would be the appointment of his officers.
Kind of. So the thing is, I would make the distinction saying that I don't think when they said that, it was their position saying that I can communicate literally anything to you, no matter, and just, again, give the in Minecraft, in my official capacity, suck my dick, and now you go, you can't use that against me, and I've deployed you, and you have to do it, and you can't use it against me.
That seems to be the case.
I would say using...
Because Robert says,
I agree with you.
with the above principles in mind, the court turns to the conduct alleged in the indictment. Certain allegations, such as those involving Trump's discussions with the acting attorney general, are readily characterized in light of the nature of the president's official relationship to the office held by that individual. So it sounds like he could literally say, suck my dick, bitch, or I will fire you. And that, I mean, this is like exclusive and preclusive. Like, there's no limit even. He takes it as self-evident that conversation
it's saying the allegations of involving the discussions. It doesn't say that like it doesn't say like any content. It goes the content alleged. So it'd be saying whatever the discussions they had with acting attorney general would be within it. What was it he discussed with it? Prosecuting cases or whatever. But I don't think it seems to be, doesn't expound beyond that to say.
But no, it does. They say that the government doesn't dispute the indictment's allegations regarding the Justice Department involved Trump's use of official power. The allegations, in fact, plainly implicate Trump's conclusive and preclusive authority. The executive branch has exclusive authority and absolute discretion to decide which crimes to investigate and prosecute, including with respect to allegations of election crime. And the president's management of the executive branch requires him to have unrestricted power to remove the most important of his subordinates, such as the attorney general, in their most important duties. The indictment's allegations that the requested investigations were shams or proposed for an improper purpose do not divest the president of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials. Because the president cannot be prosecuted for conduct within his exclusive constitutional authority, Trump is absolutely immune from prosecution for the alleged conduct involving his discussions with Justice Department officials. So they're excusing him from the allegations, right? So that's
from the alleged conduct. And so I'm saying that like I don't. So if you inserted in "suck my dick," would "suck my dick" go like, well, even discussing the attorney general sucking his dick really kind of falls within his executive authority. Like,
nothing in the executive authority involves Trump fabricating cases or fabricating letters. Let me remind you, the thing that is alleged in the indictments is that Donald Trump told his State Department that they needed to lie to the states and say they had evidence of election fraud, which they had none of. And he said that if you don't make that lie, I'm going to fire you. That's what's alleged.
He said it was a lie?
Well,
he said, I'm lying. I'm telling you to lie to them. This isn't true.
Hold on.
I'm telling you to lie.
He didn't say I'm telling you to lie, but he told them to write letters attesting to things that the Justice Department was telling him they could not attest to in good faith because there was none. He told them you need to write these letters, and Rosen and Clark or whatever saying we don't have this information. And he's like, if you don't write these letters, I'm firing you.
Okay, so again, if we went with, let's say that let's say I have the actual evidence, I show it to you and say, okay, write these letters saying that, let's say the evidence that exists, and they still refuse to go like, no, I won't attest to it. I know it's true. I don't care. I won't do what you tell me to do. Fuck you. Can he fire them? Because we're assuming that he goes, because if Donald Trump goes, I think I do have evidence. Otherwise, like I think I have evidence, and you should attest. They go, therefore you should attest to it, and they go, I don't think I have good evidence, so I won't attest. I disagree. I don't think your evidence is good enough. I don't
think that Donald Trump telling his attorney general to lie or Donald Trump lying, I don't think that either of those things in particular are crimes, but I think that they can be used in the furtherance of a crime, part of a conspiracy, and that's what's alleged in the Jack Smith papers, indictments. But we can't even consider
wouldn't any indictment then just say, all I have to do is say, I say you're lying, and now I can get you for anything? So if you go, any conversation you have, as long as I allege you're lying, I get to you. You can take it to a jury. A jury can say,
but there's probably going to be some kind of threshold, some kind of evidence that you would have to present of him lying. So like the evidence that's presented in the indictments are all of the different officials telling him over and over again, there's no evidence of this, there's no evidence of this, there's no evidence of this. And the fact that he continues on in collaboration, in conjunction with all of his other stuff, seems to point to a conspiracy.
I just wanted to say I'm here, by the way. So hello.
Okay. What were you saying, Zatsui?
Because Johnny, there were people, Chisbro and Eastman, I think, were the two like memos I've read.
Yep.
They both said yes, they both gave him information saying that he was relying on. So he had people, attorneys, constitutional attorneys saying yes. Is there like a majority? Goes, if there's enough of a majority, then you would go. You're lying if you're just following the yes man, because he didn't have no one.
Well, I think he did have no one. I think that the way that it worked in the White House, according to the allegations laid out in the indictments, maybe everybody's lying, but the way that it worked was if all of his legal counsel was telling him no, he would just bring in somebody who would tell him yes. And that's why there were so many fights alleged in the J6 Commission when they talk about all these fights that happened in the Oval Office. It was usually between Trump's newly appointed legal masterminds, it was Powell, Giuliani, and Eastman against like the traditional, like whoever the White House counsel and staff were. Because basically Trump brought these people in to say that the earth is flat, rejecting everything else that every other part of the White House and every other part of his government was telling him in order to, effect the outcomes that he wanted.
So, I mean, like, in terms of how many fired, because he didn't, like, bring in just, this is a random dude I found on the street and he says I did. Eastman is a constitutional attorney. Giuliani, like, they're not, like, just some rando you brought off the street. It wasn't like you went through everyone and you found someone who just does traffic tickets. He didn't, and so I'm saying like that it feels weird to go, I'm relying upon a constitutional attorney, but you had 6 other attorneys saying therefore I can assume you were lying. That like, so even if you have a constitutional attorney on your side, it still doesn't matter. I can still just say the word you lied because I can find people who said no.
Well, it would be in conjunction with other things, right? Like if there was a whole lot, like let's say for instance, there are 400 statements of me saying I want to murder this motherfucker, I hate this guy, I want to murder this motherfucker, I hate it, blah blah blah, and then with all those statements, and then you also look into like, okay, well who the fuck is legally, who's the legal counsel for this person? Why does he think he can murder people? And then you find out that I had fired 7 lawyers in a row, and then I hired a guy by the name of law school Murderstein, okay, some dude that went to law school and he's got a fucking diploma and he passed the bar and everything, and this is my new lawyer, is lawyer Stein or Murderstein or whatever, right? You probably look at that and you go, okay, hold on. In conjunction with all these other facts, it's pretty clear that this is not his legal counsel acting in good faith and him taking a genuine advice. He probably knows that this is bullshit. You can tell by all of the actions he's taken, so this is going to be part of our indictment.
Sure. Can I pose just a situation I've run into, and you tell me if you think like the intention, like an intentional, could be put against me?
Sure.
And you tell me like, so I had a case where there's a accident, just say it's a personal injury case, and the defense or the prosecution, I was on the defense side, demanded certain evidence of me, certain documents, and our default was we say no to it, and the person came back to me with
wait, I'm sorry, repeat that. Repeat what you just said again. Sorry, go ahead.
So I was told to produce some certain documents. That's saying like, hey, we want these documents that we believe you have. The answer is we did have them. But
okay, wait. When you said you were told to produce these documents, by a court or by the defense?
They made a demand in discovery. So they said, produce all documents related to this, this, and this.
Okay, gotcha.
And I'm going, and I respond by saying our standard objection, not admissible, or like not discoverable, not attorney-client privilege, all the generic stuff.
Yep.
They came back and said, no, you have to give, if you have this, you have to give it to me. And I was like, and they gave me their case law, their explanation why. And so I read through it and then do my own research. It had been such a default thing that no one ever objected to me before. Okay. And I'm like, oh, I think I do have to turn over these documents. So I take it to my boss, and my boss goes, no, we don't have to turn that stuff over. In fact, turning that thing over would be a violation of attorney-client privilege. That thing was privileged information. You cannot give it to them. And that we even brought in others like our little ace trial attorney to review it and say, we win on these motions, right? Like we don't turn over these documents. And I said, and they're all going, well, no, like, you're right. Nope, you can't turn it over. In fact, it'd be a violation of attorney-client privilege. Client doesn't want us to turn the documents over. But from my reading of it, none of them can explain to me why I don't have a legal obligation to do so. And so legally, I have to turn them over. And so then if I then say I do, again, it's my name at the bottom. It's not them signing their name at the bottom. It's not them doing discovery violations. It's me. Let's say I then turn over the documents. And so I go, I think I have to. And now, not only do I get reported the bar by the client for violating privilege, they also want to come after me for punitive for saying I did it intentionally. That I was told by my boss, by other attorneys, everyone was told me that I didn't have, that in fact it would be a violation of the person's rights to turn over these documents. And I did it anyways. Would you think
I feel like given the process that you've laid out there, that it seems unlikely that you would be convicted, or maybe that would even make it to court, depending on your motioning at the beginning.
I meant more civil. So the person comes out to me for damages and wants punitives, but to get punitives, it has to be intentional. They're trying to say, I can find that he intentionally broke my attorney-client privilege because he was told by his boss, by 3 other attorneys, all from his thing, all more senior
I don't
than him.
know.
They all
I
told
know
him it was a
literally
violation.
nothing about civil procedure, so I wouldn't even be able to begin to answer you there.
Would you like so if that
what I would
you
say
would
like on
say-
a what I would say on a blanket is that there might be edge cases that might be difficult to determine, and I think any reasonable person would concede to that, and that might have to be done on a case-by-case basis. And what you're describing sounds like something that would be difficult on a case-by-case basis. Nothing about what Donald Trump did is difficult on a case-by-case basis, right? Eastman was not saying, hey, listen, you as president actually have the right to go to state legislatures and ask them to, reconsider the types of votes that they allow in or blah, 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 right? It wasn't on like something like that. Eastman's theory was that Donald Trump could have a collection of people in 7 different states perjure themselves as officially appointed state electors, send in a lie about the electorate slate, and then tell the vice president of the United States to supersede the Senate and use rules based on what Eastman was saying was that the Electoral Count Act or whatever, he's saying, I think that's unconstitutional. I bet it is. And we're going to use this guy to overturn the election, right? Just on the totality of everything that's being considered, when you look at that, no part of that, to a reasonable moral human, no part of that looks like something that should be okay. Now, if he has an incredibly strong textual argument to support that, then fine, we got to patch that, maybe. But the text wasn't there because Eastman was relying on current legislation being declared unconstitutional. The text wasn't there. The actions weren't there legally because the people in those states perjured themselves. The conduct was mainly private. The president wasn't serving some official, right? So I'm just saying, like, I agree with you, to bring it all back, I agree with you that there might be some edge cases where it's like, oh, this is hard, we got to go case by case, but everything that Donald Trump's talking about is so far outside of what we would consider like, oh, this is a hard one to figure out. Should the vice president be able to throw out votes that he doesn't like? It's not even close to what's being considered here, you know?
Correct. And also not only that, the most bizarre, because I've been even just today looking at it, because what they sent to him, there wasn't a second slate of electors. So if you look at like what you need for a slate of electors, you need 2 other things other than just the signatures. You need it to be signed by the executive you need the governor's signature, and you need the seal of the state. The ones they submitted had neither. It had a picture of the seal, which isn't the seal itself, and then it had a signature by like a notary. It was like signed by a citizen. So like they wouldn't even. I don't even understand. If you open those up, it'd be like opening up a official thing of electors and a birthday card with names on it. I don't think you can accept a birthday card because it wasn't a birthday card.
Well, because on those slates, they claim that they were the legal ones. Number one.
Yeah, but
number
it doesn't
2,
matter.
They tried to send those in the way that you would transmit legal votes. They tried to mail them to NARA in Congress, I think. 3, they did try to go to the courthouse to get those seals and to say that they'd met in those areas. There's YouTube videos of them arguing with police officers outside who aren't letting them in. And 4, because they would have been presented ideally in front of Pence, Eastman was telling Pence to feign confusion and say that he couldn't figure out what was going on. Well, first he said Pence should just choose the illegal ones, but then he said Pence should feign confusion and then throw it back to the House of Representatives, who would then vote for Trump as president because the Republicans had a majority in the House delegation. That was how it was all planned out.
His actual, like, because he laid out like that. What is it, the second memo that he released, where it goes the wargaming, the alternatives for like what you can do. Here are the ways in which Biden wins. He goes determines on his own which is valid, asserting the authority to make the termination of the 12th Amendment, and then just saying like certify the electors that are done by Trump. But that's the weird part. I'm like, it doesn't. The same thing for those signatures. It's not just do you sign a piece of paper saying you're duly part of elected. Without those 2 other components, like I said, it has as much value as a birthday card in terms of it's not a birthday card isn't the sign of electors. Can you accept something that's not a sign of electors? Because if you did have that, so if you actually received it and it had the seal of the state alongside so if you had 2 slates of electors both that had the seal of the state and signed by the governor, what would you do? So what would you think? What would you say Pence should do in that situation if they actually did legitimately receive and signed by the state of Arizona?
Well, in the case of any confusion, it's sent to the ECA. It's sent to both houses to deliberate. But Eastman was saying that when it gets sent to both houses, Pence should declare ordinary rules and say that the ECA violates the 12th Amendment and both houses don't get to debate it, and then send it to the House delegation to choose the president. And the House delegation just goes by the number of states that are being controlled by each party, not the number of representatives. And in the House delegation, there were 26 states that were under Republican control and 24 under Democratic control, so they could just go ahead and make Trump the president. Yeah. None of this, by the way, like as we discussed this, none of this sounds like how any any of this should work. Like by historical matter, by textual matter, by spirit, like none of this, obviously, right, is how a president should be elected. So it's so clearly outside the bounds of any type of behavior that we'd want to protect. But yeah.
Like in terms of like that actual memo, because it doesn't just lay out here it is, it lays out like 9, like 6 of which involve the Biden win, where so it goes wargaming the alternatives, and it just goes, here's the, like that was one of them. One of them is saying here's something you might do, and that, but it wasn't saying do each one, which also seems to be though what Trump is telling people. So it sounds like if Trump read this and he goes, wait, if we do if under that, like you lay these out, C, I win every single time, so let's go with C. And you're like,
I would have to look through. I might have only read completely one memo, but I know that for one, he goes through an entire process, and he says
first
that
one straight up two, in my opinion. Like there's nothing else there. If that first one is just a draft though, so the second one it includes those, but like it lays out. They're not saying do these. It isn't saying do these things. It's saying here's all the ways it can play out, and like it starts with just saying like, well, no, you just do it and Biden wins, or if you get these objections, then here's how you do it and Biden wins. Wins,
sure,
Biden
there's like
wins.
different ways, there's different paths. Yeah, he's trying to basically shore up.
That he's laying out, all the different things that could happen and ways in which you could do it and the backing for each one. And so, but from what it seems like is, if this is the one, I would see Trump just reading Part C, going, wait, if we go with C, and if he can do this and I win every single time, fuck A, B, and D, let's go with C, and then goes to.
So you're saying like, so Trump wouldn't be held like criminally liable here or something? Is that the argument that you're trying to further with that?
What I'm saying is that I don't know. I have no.
Well, hold on, no, wait, because I think I might agree with you if that was the only thing. But because of all the other behavior that's being alleged here, though, it's pretty obvious like what's going on. If this was the only thing they had, I would say, is that really enough? Like you said, maybe he was just a retard, a con law guy. Handed him a memo. He's like, "Oh fuck it, let's do this. If this is how we like win the election, sure." Then there might be stronger arguments there. But this is just one behavior out of dozens of different actions that are alleged in those indictments, in the indictment.
Yeah. So my overall feeling is just I'm tired.
Sure.
And the problem is I'm frustrated by the entire thing. I'm frustrated by the decisions. I'm frustrated by how I feel like there could have been so much easier clarification to either affirm what they're saying or not. They're leaving so many gaps. Like the SEAL Team 6 thing, I don't suspect it will happen, not because it's like, well, textually I think I can see it. The problem is you'd be playing a Russian roulette there to go. I sure do hope that the dissent's reading of it is correct, because the majority says they're wrong but doesn't explain it.
I don't think we should take that for granted. The electorate, this whole scheme is pretty wild and like probably one of the worst things outside of like I guess the Civil War that like a president has concocted to enact against the citizens. Like on my limited understanding of Watergate just the electorate thing on its own seems to like easily be worse than Watergate. It's like not even close. So like the idea that the SEAL Team 6 thing is so far outside of the question, like keep in mind that like let's say that he does SEAL Team 6 tomorrow, right? Sure. People like me are going to be saying things like, well, you don't think it meant anything when Trump said over and over and over again that he needs to suspend the Constitution for martial law? You don't think he meant? Yeah, go ahead.
If he did the SEAL Team 6 thing, you'd back that and say yeah, like, and if let's say he SEAL Team 6 is
I would say it wouldn't be
power stabs him to death.
I would say it wouldn't be beyond the pale. I'd say like, yeah, this is not that unexpected. I don't think. No.
And so if it went to Supreme Court and he goes no, and they clarify and go no, this isn't fucking covered, and throw him and go, and then he's prosecuted for prison, would you be like, well, at least we've clarified it?
I guess, yeah, but I don't know what the current reading of the court. I don't know how, depending on how he does it.
Because they haven't clarified. So I'm saying that's where my concerns are probably a little bit lower, where I'm saying that it's not the statement of the dissent. If the majority just said, yeah, the dissent's totally right, immune, like that whole like hyperbolic immune thing, we agree with every part of that, but they seem to be saying you guys are nuts, but they don't expound on why. And so if you try,
but they've already given him
opinion.
They've gave him absolute immunity for that attorney general conversation. That's an action that I just would have never expected a president to be like absolutely criminally immune for, just because this act happened during a conversation about who the attorney general should be or about firing an attorney general. That's wild to me. That's not even up for considering. That's not even up to fight the presumptive immunity. I was given absolute immunity.
Yeah, but I guess I disagree on the position we're saying that it is that like it would cover the dick sucking. I don't think like he goes, well, no, it's covered. I was talking to my attorney general about sucking my dick, and therefore it's covered under my official conduct, because I don't think the official conduct is just talking to him. I think it'd be discussing it would have to fall within that. It would be discussing.
Wait,
with
no,
your
no,
attorney
wait.
general
Okay, well
who
then
would
I would push you, because I'll source if I
Sure.
want. I'll read what I've read. I would push you and tell me, why do you think that? Because I think that the text of Robert's thing says that if he were to condition keeping his job on sucking his dick, that would be an absolutely immune act that the president of the United States is beyond judicial review on.
The word is alleged conduct, where it refers to with respect to the conduct alleged in particular. And so it's not saying like any, because otherwise they could have said like any conversation with him, no matter, doesn't matter, the conduct's irrelevant. If you talk to him, any conversation regardless, including sexual favors, would totally be, obviously wouldn't like the last part, but just saying like, but when they say no one is alleging that the conduct wasn't official, because like saying who you should and shouldn't prosecute is official conduct, but sucking your dick would not be official conduct.
I think the difference there is talking to the office versus talking to the man, because the unofficial acts are personal acts, is separating Donald Trump from the office of the president. So in the same way, you'd separate whoever the attorney general is from the office of the attorney general. So the question would be, are you talking to the office of the attorney general, or are you just happen to be talking to the person who just happens to be attorney general?
Yeah, but then if you were to try to argue that there's a significant difference between these two things, you have to overcome the burden that by delineating those two actions, you are not placing an undue burden on the executive, and that you're not essentially piercing that immunity in a way that would provide for dangers of intrusion on the authority and functions of the executive branch. You'd have to do that to overcome that.
Well, I'm not sure that's quite true, because if I can make the argument that I'm just talking to the guy, then it's an unofficial act. The fact that he happens to be the attorney general is neither here nor there.
Yeah, but you're talking to him about matters directly related to the Department of Justice. How could that just be you talking to a guy? It's clearly the president talking.
That goes against my presumption of what I was saying. So.
Well, but the conversation Trump is having with the AG has to do with his functions as the attorney general. Whether or not he's going to fire him, whether or not he should mail letters or start sham investigations. Like, these are all, like, starting investigations and hiring and firing is all.
Sham investigations are not. I'm saying that the whole thing is we're going, I don't think Trump said this is a sham investigation, do it anyways.
No, but that's what's being alleged as part of a criminal conspiracy. But what they're saying here is.
Allege that.
What?
You have no immunity then, because I can always just allege it. I can just allege that it's a sham.
No, right? You can't allege that now, though, because that you can't allege that.
Well,
because, what?
You think it should, though, right? Like, that's what you believe, that I can get to you anything you do so long as I just say it's a sham in front of it. I can Minecraft the opposite direction. Like in Minecraft.
Wait, I don't understand what you're saying.
Every single thing. So let's say there's a core duty that should be, okay, you did that, but it was a sham, so now I can criminally prosecute you. So rather than saying in your official conduct, any prosecutor can just say you did that as a sham, therefore I can get you for it.
Well, hold on. Why wouldn't that work with an ordinary citizen?
What do you mean?
That's not enough. You can't just claim that what somebody did was a sham, so now you get to take them to criminal court over it. You're going to need other evidence to even bring the case to criminal court. That wouldn't even survive probable cause, right? But even if it did survive probable cause, you'd also have to get a grand jury to agree to issue the indictments.
And the whole I can indict a ham sandwich thing? That's like I said, this is where the distrust saying like that.
If you want to say that you're going to indict a ham sandwich, that's fine, but then kill yourself. If you're a Supreme Court justice and you're so worried about your branch of government being undermined, and now you're going to literally undermine the entire authenticity of your criminal justice system by saying, well, anybody can be indicted for anything at any point in time. Okay, well, then why the fuck are you even in government? Like, if you think it's all a fucking joke. And in that case, none of this shit is going to help Trump anyway, because people will find reasons to indict him for non-official acts, and none of this will protect him regardless. If you really think the system is that much of a joke, then nothing that you say from the bench is going to help him.
I need to read more, because the thing is that the thing where you're saying that he keeps doing it as a lie, he keeps doing it as a sham, he doesn't appear to be like, and if he fires someone, does he say, because has there been anything besides implication that isn't like reading into him that he said it must be a sham? You go, well, other attorneys, that's why I said, like, to give you the example saying, if enough people tell you no and I say yes, is that enough to assume that I'm lying?
No, hold on. You keep saying, you keep doing this thing where you're vacuuming it out into one thing. If it's just one thing, then I would say no. But do you agree that if this is a pattern of behavior that I can corroborate with like 50 other actions, that I can probably start to use these things to support each other, depending upon the type of evidence?
Yeah. Yeah, I guess the problem.
Like if I were to be like, I really want to fucking kill my wife, fuck this bitch, right? You can't take me to fucking criminal court for that. You can't indict me on that. But if I make that statement online, And then I make that statement to a bunch of friends privately. And then I go to the store and then I buy a gun. And then somehow she ends up dead. And the casing is, 9mm that looks like it might be from a 9mm handgun that I just bought or whatever. Like, you don't think that those statements couldn't be brought evidentiarily that like, oh, well, you said that you were going to kill her. You were being serious. I was like, I was just joking. Like, I feel like that would probably be deliberated in front of a jury. That'd be my guess. But you wouldn't say that you're not indicting him just because of the joke. He just said a joke. We're going to indict people on all jokes? No, it's not just the joke. It's that plus a whole bunch of other things.
But what I'm saying is that if he had said like, hey, this is totally fake, wink, wink, joking, but totally do it. And he said like that over and over again. But I'm saying that it's never, I don't believe there's been a single time where he said, this is a lie.
No, he hasn't. No, of course not. But in no criminal court do you expect a confession to come from the defendant in order to prove that he's like telling a lie. You don't need that in any criminal court. For instance,
the examples you gave was the joke, though. It was saying like you did say it, but you were like you're arguing that you were joking, but you did say it. And I'm saying, did he ever say it? You're going off of he never said it, but I don't expect him to.
I mean, like, let's say there's a rape case, and let's say the woman is saying, like, please don't fuck me, I don't consent. And then someone else is saying, like, oh, yeah, like, I know that girl, she would never fuck you, she doesn't consent. And then, like, the parents and the siblings are there, and it's like, oh, no, we know our daughter really well, she doesn't consent. Like, we're not going to allow her to do this or whatever, like, she doesn't consent. And then let's say that you find one friend who's like, that bitch, I saw the way she winked at you, okay? She definitely consents. And then you fuck her. Can't they bring up the fact that, well, look at you actually had a consent expert. Let's say that you hire an expert on consent and you bring him with you. And that expert on consent says, oh, I'm checking out this girl. She's definitely not consenting. And then you find some random fucking dude on the street who's like, oh, I think she is. Go fuck her. And then you fuck her. And now you're in court for rape. They're probably going to say, well, hold on. You literally have a Department of Justice. You literally have a consent person who's supposed to inform you on whether these things are consensual or not. And they said no. Much the same that Donald Trump has a whole host of investigative organs that were all telling him these exact claims. This is not true. This is not true. This is not true. And it's all listed out in the indictment. But Trump repeated these things anyways. And he said they were true. That all goes, I think, to furthering the intentionality of him lying. It's not like he just like was misinformed. He'd been told by people that he ostensibly trusted for other investigative purposes over and over and over again that these things weren't true. But he repeated them over and over again to further his own ends.
The person you gave an example there was like some random jack off, but if you got like another consent expert, so like it was the friend, the one consent expert, the mother all saying no, the other consent expert says yes, and he goes, well, I don't believe you guys, I think it is, and he finds a consent expert who says yes. Yeah. Then do you still have it?
Exactly. Yeah, because that's what the indictments were proving, or that was laying out all the different people in his government that were telling him, like, hey, this isn't real. Hey, stop repeating this. Hey, we haven't found evidence of this, but he was still repeating it. And then let's say that he goes to his consent expert and he says, hey, listen, you need to tell me that I have consent, or I'm going to fucking fire you, and I'm going to find a consent expert who will.
You're not seeing enough, because the thing is, so in terms of like people that were told him, like, how many people were fired? Like he said, like they said no, they were how many attorneys were fired that said no to him?
Well, supposedly for the attorney general thing,
was Eastman.
For Rosen and Clark, I'm thinking for the acting attorney general and the acting assistant AG, when he threatened to fire him, according to I think this came out of the J6 Commission. I don't think it's in the indictment, but supposedly like half of his staff threatened to quit if he was going to fire the acting attorney general because the acting AG wouldn't send those letters out that he wanted to. So he decided not to fire the. There
were also attorneys that quit during the whole elector thing that said like I don't agree with this and I'm not even like I quit.
Oh, there might have been. I don't know about that.
You do this. There was some more of those as well. Yeah. No, I can see what you're saying. And but again, like I said, that there's you're right. The fear that like I said, that's what it seems like what the conservative court is feeling is the fear that you're going to try and do something more. And you're saying that, no, this isn't one of those crazy situations. This isn't something that you can get past. There's so much overwhelming that we're past that threshold that the idea, if you're afraid of this, you're afraid of literally.
Mm-hmm.
But I do think the minority fails when they don't worry sufficiently about what will happen in the future, because once you break the dam, the idea that this will not set a tone for future actions is somewhat naive, because the common law has a very strong tendency to expand, especially by ambitious prosecutors looking to make their name.
Bullshit.
So even if you
no, hold on, it's always been assumed, and every president has probably acted under the assumption that they can be criminally indicted. Remember, for the Mueller investigation, there was this whole question of like, are we allowed to criminally indict a sitting president? Right? That was the consideration. And we're saying that in an era where every single political person was wondering if you could criminally indict a sitting president, that the operation of the president, that all the prior presidents had operated under the assumption that I can't be indicted ever for official acts. What do you mean if I'm sitting? I could be sitting, standing, or fucking flying. You could never indict me for an official action. That has never been the understanding of any ex-presidents. Otherwise, why would Nixon need to bring a civil matter? Why would Nixon v. Fitzgerald be ruling on whether or not you could be civilly, held liable for damages if they thought they had infinite criminal immunity? Why would Nixon have ever accepted a pardon from Ford? Why would Ford ever offer a pardon to Nixon? I disagree.
Well, I think that might have been just for
We
political.
keep saying official conduct. We're not saying that like you are criminal for either official conduct. There's only a presumption for the tangential stuff. But well, so for like FDR, why wasn't he indicted for internment camps? Yeah. Like if we're saying that like he's criminally liable, you attack. I mean, you went after just American citizens with nothing, just because like they have the color of their, just because you think they had some ancestry, and you put them all in internment camps. We've never put anyone. We've never even tried any of this. This is the first time we've ever done it. Is this the worst thing that any president has ever done?
No, hold on, hold on. Stop. Okay, both of you are lawyers practicing. Okay. It's not about the worst thing or the baddest thing. We're talking about criminal law. So the question is do these things violate criminal statutes? Okay? Cheating on somebody and fucking their brother and their child and their parent, assuming that all of them are of legal age, none of that is a criminal thing, but that's probably worse than stealing somebody's $5 bill, which would be a criminal action. So we're not asking, is this the worst thing a president has ever done? The question has to do with legality. When you mentioned internment camps, I don't know if there was ever a question of the mens rea of the president in trying to perform a criminal act here ever. I don't even if it was wrong, even if it ultimately ended up being violative of the authority granted to the president, I don't know if there was ever a question of, is he doing this just because he hates Asian people? Were there logs of him, or not logs, I guess would have been telegrams, were there letters, were there statements like, oh, I'm going to get these Japanese people, I'm going to fucking get them at some point, I'm going to get them. Like, if that was the case, then I think we have something more comparable, but I don't think there was ever any indication that it was done as some personally punitive thing to just fuck with Asian people because he hated them personally. That's my
what's required? I don't think that's like, so I'm saying, is there no criminal law that say that like, he says he did it, it was done under his commander-in-chief for the war. Mm-hmm. Is there nothing that, that you're saying that no, we tried and we just couldn't come up with one? Because I'm saying like, I couldn't look through it. I mean, I'd have to look through it.
I don't think there was even a question of, did he do this for matters of, for like a criminal.
Even intent.
Intent is everything. It's criminal law. What do you mean?
Well, no, I'm saying if he intended to put them in internment camps, is what I'm saying.
Actus reus is only one part. You need the mens rea. An act in and of itself, stabbing somebody doesn't tell me if it's murder or manslaughter. That's going to be the same action. You need
both crimes, though. I'm saying that.
Well, hold on. Not even necessarily stabbing somebody. If you trip and fall because somebody pushed you or some bullshit, correct, maybe reckless endangerment you get somebody. It's not necessarily a crime to stab somebody. If you're performing surgery on somebody, it's not a crime to stab somebody, right? I'm just saying the act itself.
Yes.
If he's a public official and he's charged with the public protection as the executive, and part of that public protection extends to things like keeping the country safe in times of war, he probably has, and he has had historically, broad executive power to enact what he believes keeps the country safe, right? Now, we might later go back and say, actually, this is too far. We either need to amend the Constitution, changes, or we need to pass a law if we think it's constitutional to change this. But I don't think anybody at the time was thinking the president was engaged in criminal conduct, right? That he was engaged, he had the mens rea to do something that he knew he probably wasn't allowed to do this thing, but he's going to do because he fucking hates Japanese people. I don't think that was ever a question that anybody asked. I don't even think
it's saying like you're going for more of intent than I'm thinking. I'm saying that like if you knew that some of the people you were putting in were not, that they all didn't declare themselves, you didn't go through any due process for any of them. You knew you were violating that for innocent people, and you did it anyways. You can say that you have your rationale for it, because in your official capacity, I had to do it because they had made this argument. There had been I think there had been some individuals, so just to cover our butts because we're in the middle of war, here's why we did it. But that sounds like giving your rationale as to why you did it. In the same sense, where like the SEAL Team 6, I assassinated the person. You're giving me your rationale, but if I disagree with it, you think I should be able to hold you criminally liable. If I disagree with why he did it, why can't I hold him criminally liable?
Well, the question would be, so like, what was FDR's process for doing it? Did FDR confer with his Office of Legal Counsel and his administration to figure out if this was a legal act or not, or was there some contemplation on this beforehand?
Is that not for the jury to decide? You should be charged, though, right?
Well, would it be enough for a jury to decide? I don't know if it would make it past. I don't know if it would even make it past the indictment stage, right?
Why not? Like, so like, what under what immunity? Why would he be immune to prosecution? Why would you remove it?
I mean, there's
Because
going to
when I
be
say
some.
bad,
Well,
I
hold
mean,
on. There's
like,
going to be
the violations
wait,
you've
wait,
done
wait.
to people
There's
are
going to be
severe.
there's going to be some level of at the very least qualified immunity, right? Like you don't always take like the qualified immunity that a police officer enjoys in carrying out his duty. That's not an affirmative defense presented at court. That's like prohibitive of him being like charged with a crime, right?
Yeah.
So
We're saying that he shouldn't have absolute immunity, but again, that would be something where it would be. But did we get to that point? Did we even charge him with that? And we go, we think this falls within underqualified. We didn't even try. That's what I'm saying.
Yeah, that's fine. But what you just said there, I think that's fine for a consideration to be made. Yeah, for a prosecutor to look and go, do I feel like a criminal law was violated here? Maybe he does. Maybe he wants to make that argument to a judge and says, I think I should be able to file this, blah, blah. Maybe the judge disagrees. Maybe even the judge is like, yeah, okay, fine. And then maybe you try to indict him for it. Then you have to get a grand jury to agree, right? The grand jury would have to agree. And then after the grand jury agrees and they indict him, then the defense, who, by the way, is equipped with the smartest and most able-bodied defendants or legal counsel probably in the world, because you're talking about the president of the United States, then they have pretrial motions that they can go through. They have, I think, interlocutory appeal even for the president to have this dismissed at any part that he can appeal the ruling even before the trial is done. There are so many parts of our criminal process that are we really thinking that every single part here is going to fail just because of a political bias? Because remember, I hope we all agree, even Roberts, I hope we all agree, we're not trying to protect legitimate criminal activity, right? We're not actually trying to protect legitimate. So the assertion is being made is we feel like the federal prosecution system is going to fail at every single step and is going to bring charges and a conviction to a president, or at least sufficiently damage his ability to function on bullshit ass charges. That seems like a very sad analysis of our justice system, but I think that analysis also precludes your ability to make any ruling at all. Because if it's truly that fucked, then no ruling is going to help him anyway. People will just bring random criminal charges.
I do see that in some parts of the world, though, where there's just the indictment after indictment of political leaders.
Wait, why would we compare other governments? We're looking at the United States, right? And we're looking at our
We're trying to look for the tendency of what's going to happen once you open this dam. We're trying to figure out what's going to happen in the future once you change the premise, because this dam has never happened before. Once you do it,
well, then we would look to the past. We would look at the foundation of our country, and we would look at a king that existed to some extent above criminal prosecution, and we'd say, oh, well, we probably don't want that. That's probably what the country was founded on, was a king not being above the laws, where the only thing you could have are his counselors or whatever held criminally liable, because the king himself could never be criminally charged. That would probably be looking and say, oh yeah, well, obviously our chief executive can't be criminally charged because he's like a king. That's the American conception of government.
It's more of saying that, like, if this is the threshold, has anyone done anything that could also reach this? So if we say yes, you can charge him as you did. I think the example they gave at one point was saying that the whole immigration saying, like, that there is federal law against like obstructing the different departments. So if you try to tell someone, don't enforce this immigration law, once the president's out, can the next one say, he didn't enforce our immigration laws, he obstructed the duly process of that department, charge him with crimes? And it'd be valid. Like, we'd have to go, yeah, well, I mean, he did get in the way of the department. The department's rules say that, and he said, don't do it. I mean, he even like went after Texas, going like, well, no, you have to let them through. You're not like that.
Hold on.
If you could say
is obstruction in regards to that criminal statute, you're mentioning the one that they're trying to get Trump under, is that sort of obstruction? If we go on Google and read that criminal statute, would that extend to simple speech? Like if you just say like, hey, don't do that, guys.
Well, no, but he's saying he directly orders the department not to enforce those rules. So if there's a law in the books for the executive branch,
it wasn't obstruction. I was trying to find the exact reference.
It wasn't the word. What is it? It's our impede, limit. Some, like, there's a lot of things where it goes conspiracy to. I search the word conspiracy. I think that's what it started with. So if you search the decision and start with that, it should pull up there.
I mean, if the president is failing to enforce laws, that would be an abdication of his duty. Obviously, impeachment would qualify here. Has a crime been committed? I mean, I guess it would depend upon.
No, there's too many words to confuse here.
Yeah, I guess it would depend upon. Yeah.
Do you understand at least the fear, the idea of saying? And I think you've acknowledged this before. Is I'm not even saying like that wrong, but there should be deference given because there's a fear that says if each time a president comes in, they instantly start searching for a reason.
Yes. Hold on. I understand that. I can respect that. But the problem is Roberts only respects one side of that, okay? On one side, you have the fear of infinite criminal prosecution of a sitting president or an ex-president. But what is the other side of that?
Is the big old king, the king getting away with everything.
Exactly.
Basically.
So then the question is...
The dissent's on the other extreme, though, because they're basically like the president should be held responsible for everything without limits.
No,
To the
hold
maximum
on.
extent that
Excuse
anyone
me.
else would.
Excuse me.
That's the way
we
at least I
have
read the
limits.
dissent.
It's called our entire criminal justice system. It has a ton of limits that are built into it, a ton of provisions that are built into it. Unless we're willing to say that that entire system is garbage, like that's what's built into it. And that's arguably what's kept presidents thus far from being criminally indicted, because apparently it's been possible. Again,
I think the particular problem with the president is because he is the executive branch unto himself, he's in perhaps a unique position having liability, or at least theoretical liability, under every possible criminal idea that could apply to any particular executive. So if you just take a random bureaucrat in some position in the federal government, their criminal liability for potential actions would be a far diminished subset of what could apply to the president. So the president's liability is unbelievably expansive. And so the idea of trying to find some provision that could apply to the president because he's the entire of the executive and encompasses everything.
I don't even
the
know
idea of
what
trying to find some liability is potentially infinite.
What do we
it's
think?
a real problem.
What is a criminal action that we feel like the president probably needs to be close to perform his job as the executive?
Can you restate that?
What do we think is a job that the president has to perform that could be easily confused with a criminal action that he needs to be able to do to perform his job?
To some extent, we don't even know, because the Office of Legal Counsel long ago gave up even trying to count the number of federal laws that exist.
I don't know.
They can't even count them. There's so many.
Wait, what do you mean we can't count them? Can we literally Google like the number, the law?
No, because of when you have all these, when you have incorporations by reference, and you go to the Code of Federal Regulations, which often incorporate other things by reference, it becomes
What do you, when you say incorporate by reference, you mean just references other laws?
Yeah.
And we're saying nobody can count that? I feel like that must be.
I have a different answer then.
Well, wait, hold on, because like if we have 5 laws and then we make a 6th law, and that 6th law incorporates laws 1 through 3, we would just say we have 6 laws. No.
If Law 6 incorporates laws 1 through 3, then arguably you have now 8 laws.
How would you have 8 laws?
Because there's 6 law. Because you had 5, and your 6th law now incorporates 1 through 3. So that's now 3 additional things.
Because I guess you could charge them under 1, 2, 3, 4, 1, 4, 2, 4, 3. Like that's how you're meaning. Yeah.
Can I get an example of like an incorporated
all those different
law?
combinations.
What's like a legal statute that is like has incorporates something else?
A lot of the Code of Federal Regulation does. I could find you exact examples, or I could find you the quote.
Wait, you said Code of Federal Regulations?
Yeah, that's just the official the CFR. It's all the regulations that the executive branch publishes with respect to all the agency rules and stuff like that. It's what for example, the ATF was trying to do with bump stocks. They said they tried to publish it as a regulation and said under regulation the bump stocks are illegal. So that would be an example where they're trying to criminalize something under a regulation rather than there being a statute that said bump stocks were illegal.
Okay. Okay, so there's a lot of federal laws, I guess. Why do we expect an ordinary citizen to be able to function within our criminal laws if the president can't, who has access to more legal counsel than anyone else in the country?
Yeah, so I go back to what I said earlier. Like for any particular citizen or any particular member of the executive branch, you are talking about, like, there's a whole bunch of statutes that even couldn't hypothetically apply to me because I'm just not in a position where they could even potentially apply to me. Just to be a really stupid example, I'm not a power plant, so I don't have to worry about emissions regulations or polluting the waters or any things that might apply to that sort of domain. So my potential liability is much smaller because only some of the law even hypothetically applies to me. If you're the president and you are the executive branch under yourself, you arguably now have all the law that could hypothetically apply to any member of the executive because you are the executive all at the same time.
Yeah, but if Congress has authorized you to do a thing, you can't be charged with breaking a criminal law for a thing Congress explicitly authorized you to do.
Well, apparently you can if you don't do it in the right way. That was the concern.
Well, no, that's good though. Hold on. Don't we want that to be the case if you don't do it in the right way? If you do it in a way that is criminally prohibited? Wouldn't we want somebody to be maybe keeping that in mind?
It's a lot to keep in mind. I mean, like
it's a large amount of power to execute. That's a good thing, though. But hold on. When you say it's a lot to keep in mind, that's why the president has a cabinet. That's why he has officers that fills his office. That's why those officers have sub-officers, and that's why they have all these people that man all these administrations. We've got such a big bureaucracy, and we've got a whole special office of legal counsel, and we've got the entire DOJ. Like, yeah, it is a lot to keep in mind, but that's why the executive is tasked or staffed with a whole bunch of resources to keep that in mind. Wouldn't we want that to be the case? Again, to return to my central question, what do we think the president is going to do that's going to come close to like breaking a criminal law?
So my answer, like we went down a little tangent there, but let's go with let's say Israel-Palestine right now. There's people, let's say a leftist president came up next and wanted to go, I mean, everyone's calling him Genocide Joe. They're blaming him, saying that he caused the genocide. Would they not charge him with genocide, saying that you intentionally tried to kill them all? The ICJ.
Wait, hold on. There's not even I don't think there is a U.S. law. Is there a U.S. statute against genocide even? Let's start there.
I'm more of saying that, like, do you think that they couldn't concoct? Do you think there's no law that could be concocted against it?
I guess you could. I mean, you could try to get him on, like, I guess, like federal murder or whatever on a Palestinian. But then, I mean, okay, well, now we need to go to a judge, and we need to see at least like prima facie, can we make a case? Well, what are we even putting in our? Is it a complaint for when a DA files the initial thing? Is that a complaint, or is it just called a complaint for civil matters?
You can call it a complaint.
Okay, so when the DA files their complaint with the judge, first we have to see if we've even asserted enough in the complaint to have broken a law, right? Well, the president acting in his powers to sell arms to Israel that's literally, the legislature has delegated that power to him. He can't be breaking the law in that case, right? Well, do we have evidence of, like, are we asserting even in our complaint that the president has even said or given any indication anything remotely related to murder? Maybe the president has said, we need to do whatever we can to stop the things happening in Israel. Maybe you say to the judge, well, anything you can. Maybe that's like a murderous statement. The judge is like, oh, fuck it, fine, whatever. So the judge approves the complaint. Well, now you've got to prove to a grand jury that those statements are strong enough to indict. Are you going to convince, I don't know what his grand jury is, 10, 15, 12 citizens or whatever?
It's usually 23, but you only need a majority.
23? Okay, so you have to convince a majority of citizens now that statement alone is something that shows like a murderous intent.
Yeah, I guess because you're right. Because the point is basically saying there's enough safeguards in place that this is unnecessary and this is expansive beyond that. And so the idea is saying that what could possibly get through all these safeguards, such that you're doing this and that you're trying to directly protect Trump because his behavior is so beyond the pale that it would clear all those safeguards, and so you're having to raise the wall beyond what is reasonable.
And then conversely, let's flip that. So we've considered, like, okay, well, fuck, what if somebody tries to hold him criminally liable for stuff going to Israel Palestine? Okay, but now let's flip this, and let's say we ride on the my interpretation of the Supreme Court decision. Let's say that Donald Trump decides to visit Israel Palestine because he's saying that we want I want to go talk to my Israeli people because I love Jews and blah blah blah. And let's say that Donald Trump is standing on the beach in Tel Aviv and he's talking to these people, and then boom, he gets drone striked. Okay. And President Biden gives an address, 5 seconds after, and the address is just him turning on the TV, and then the drone striker turns on the background. He laughs at the camera for 20 seconds, and then he turns it off. Are we going to say in this case, are we going to turn around and go, wow, we're definitely going to impeach him so that he can't run for president again? That's what we're going to say? That's all we have?
I do think it's unclear from the majority's opinion.
Yeah, that's what my position is.
What's unclear? The president ordering drone strikes is not an exclusive and preclusive.
Say as to the immunity if he is impeached and convicted. That was what
no, it's not unclear. They rejected that argument. They completely rejected that argument about the convictions and stuff following the immunity. Otherwise, they wouldn't have called it absolute immunity.
I think that it might be absolute immunity with the caveat of the impeachment.
You understand, as soon as you say caveat, there is no such thing as absolute. Those are words that are contradictory to each other, right?
Yeah, it wouldn't be
the question
the first
would
time
that
in
fall
law.
under the absolute? The thing is, like I said, I disagree. Like, I don't think it's 100% clear. I wouldn't say, so I can see the reading of it. But again, going back to like the whole dick sucking thing, I don't think that would be clearly covered within the majority's ruling, saying, yeah, if you communicated to your attorney general to suck your dick, and said in your official capacity beforehand. Same thing with the drones. You can't just say, I want to do a drone strike, which is official capacity, and now anything I say that follows from it is attached to the drone strike statement. I don't think that follows. So, like, I think the example that was it that Bill Barr said, like in his thing, where he goes, whether you hire a hitman to kill your political opponent or whether you use SEAL Team 6, using SEAL Team 6 doesn't give you protection for the hitman. You still or doesn't give you
what is
coverage for the killing your political opponent.
What's the language, real quick, of the impeachment clause, so I can look this up real quick?
Treason, bribery, and other high crimes and misdemeanors, I believe is what you're looking for.
We were just talking about, which part of this was this? Roberts rejected the, nevertheless, that's the word I'm thinking of, I think.
Yeah, he said that nevertheless was basically that he was trying to carry too much, trying to do too much.
Yeah, Roberts threw that entire argument out.
Yeah.
So I don't know why we're saying Roberts didn't rule on it when he threw that entire argument out.
Wait, what is it? Wait, stop scrolling up and down.
I think he says exactly the opposite. If you just go to the thing you just highlighted.
Yeah.
No, that wasn't the opinion. That wasn't the majority opinion.
Oh, fair enough.
Wait, I don't think, unless I was at the wrong spot. Hold on. Oh, here we go. Trump asserts a far broader immunity than the limited one we have recognized. He contends that the indictment must be dismissed because the impeachment judgment clause requires that impeachment and a Senate conviction precede a president's criminal prosecution. The text of the clause provides little support for such an absolute immunity. It states that an impeachment judgment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the U.S. It then specifies that the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. The clause both limits the consequences of an impeachment judgment and clarifies that notwithstanding such judgment, subsequent prosecution may proceed. By its own terms, the clause does not address whether and on what conduct a president may be prosecuted if he was never impeached and convicted. So Roberts is stating very clearly here that that clause does not address at all what the president may or may not be convicted on. So he's completely...
If he was never impeached and convicted.
But it doesn't say if he was.
It does address what happens if he is, but not if he's not.
So yeah, because it's saying that if he was, so that if you do something, let's say that could get you impeached and convicted, but
no, hold on, no, I'm sorry. Let me reread this. He says, Roberts says, the clause both limits the consequences of an impeachment judgment and clarifies that notwithstanding such a judgment, subsequent prosecution may proceed. So if the clause is limiting the consequences of an impeachment, then the limit is. It states that an impeachment judgment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit in the United States. That's the limit.
And then specifies that nevertheless you can be held liable to indictment relevant to law.
Yeah, according to law.
The impeachment conviction itself
can only do
doesn't extend further than being kicked out of office. But as a separate proceeding, you can then bring the criminal proceeding.
Yeah, so if you get impeached, at least my reading of it, seems to be if you get impeached and convicted from impeachment, all the Senate can do is remove you from office, but afterwards, here comes the criminal charges.
Wait, but he says the clause doesn't address on what conduct you may be prosecuted. Oh,
if he was never impeached.
If he was not.
Okay, so we're riding with potentially Roberts was saying that if you were impeached, you could be indicted on any of that conduct. But despite the fact that he's making a novel argument for absolute immunity, he never mentions that incredibly important caveat to it.
I would agree with you. He doesn't mention it explicitly either.
No, hold on. He doesn't mention it at all, ever. Wait. Don't say explicitly. He doesn't even apply. He never says that if you want to indict Trump on some criminal matter, you have to impeach him for it first. That's never mentioned in any part of Roberts' opinion.
Correct. It just says you could be. If you are impeached and convicted, you can be. And if you're not, it's not. It doesn't tell you.
You don't think if Roberts was going to say, if he wanted to give one important out to the dissent or one important out to people that disagree with his opinion, you don't think Roberts would say, listen, if you really want to hold him criminally liable for this, you need to impeach him for it first? You don't think he would mention that anywhere?
Wait, does that not just say that? Did we not just read that? It says, like, if you are convicted and impeached, then it does that, and you then will be subject to criminal prosecution. Does it not say that? Did we not just read that?
No, he's saying that Trump asserts a far broader immunity than the limited one we have recognized. He contends that the indictment must be dismissed because the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. The text of the clause provides little support for such an absolute immunity. It states that an impeachment judgment shall not extend further than to removal from office It then specifies that the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. But that's what the Supreme Court decision is ruling on. It's saying nevertheless means irrespective of what comes before it. It's not saying nevertheless, we're going to give you the ability to do a special type of prosecution that we wouldn't agree in any other circumstance. No, that's not a plain textual reading here.
It nevertheless is just despite that.
Yeah, exactly.
So
Despite
despite the fact that he was convicted in the Senate,
He'll also still be
he
liable.
shall,
in
despite
those.
that, also be held liable
to indictment, trial, judgment, and punishment according to
Yes.
law.
Right.
Yes.
But they're saying in the law, but they're
It's-
saying a reading of law says you have absolute immunity from certain acts. There's nothing in here that's implying that there is a special type of criminal prosecution that can pierce that absolute immunity veil that Robert has given President Trump here. There's no reading here that supports that.
The question is, can you be impeached and convicted under something, under your official? Can they say, like, we didn't like who you pardoned, we're impeaching you for that?
Yes.
And now
And I
someone
think the
can
answer to
sue
that question is yes. I think they can impeach you for literally anything.
You
that
can be
strikes their
impeached
fancy.
for anything
Yes.
you want to be impeached for, yes. But the
Okay, so
impeachment
then
has nothing to do with the criminal. Impeachment is not a criminal proceeding and has nothing to do with
Yes.
criminal proceedings. Yeah.
Wait, I'm not seeing the problem with that wording. That seems correct.
Wait, what seems correct?
What he just said, so that he goes that what happens in the impeachment, because I can impeach you for whatever the fuck I want. It doesn't
Correct.
mean that therefore you can convict them under something else, and it doesn't absolve you either. So you can't say like, well, no, I was impeached under it, so you can't get me under criminal for double jeopardy. You go, no.
Correct.
That's its own
probably
thing,
that's what
and
the
we can get you afterwards.
Surely
Is that
that's what
not-
the framers of the Constitution intended. Yes. But you guys are
And is that-
arguing that when Roberts is saying there's an absolute immunity, because Roberts references this part of the Constitution, Roberts isn't saying that, well, if he gets impeached for something, he could be indicted and then like that he could be charged with that particular crime as well, even if my absolute immunity would have covered it otherwise. He's not saying that impeachment unlocks that.
Yeah, no.
He's not saying it, but the premise that it's built on is that this is required by a separation of powers. But the idea here, at least, is in this language that we're reading, I would read it as strongly suggesting, although not explicitly stating, that if the Congress does this thing that is authorized by the Constitution, then that's not a violation of separation of powers. That's furtherance of the separation of powers.
Yeah, because
and so
all
at
you can
that
do is
point,
remove
the
him.
criminal liability is now no longer a separation of powers concern.
How
So
does that
Congress
address
can
anything?
remove the
I don't
immunity by
see
this
that.
impeachment process.
Wait.
No?
Wait, what?
I don't think so. No.
Okay,
I don't
fair
think
enough.
I don't think. At least, I mean, I'm not saying. I don't think. It seems to me that saying the impeachment doesn't violate it because all they can do is remove him and disqualify him. And so the idea that goes, oh, I'll do whatever they say, otherwise they'll remove me. Like that's not as versus saying I'll put you in prison. That's saying that those are independent of each other. That we don't care
Maybe
whether you
perhaps I
impeach him or not.
misspoke. I don't disagree.
Okay.
Yeah,
but
they can impeach him for anything, but having done that, it's no longer a violation of separation of powers to hold him criminally responsible because the political process of impeaching him and removing
Hold
him
on. No.
It's criminal liability.
The idea
see
that
that.
it would have been violative to charge him
rather.
criminally beforehand, we're reading way too much into that. I don't agree with that.
no, because even if let's say you impeach him on something, if they try and go after him criminally, it wouldn't just be against him; it would be against future people. If you go after him for some other decision, that means you're still revealing that you're criminally liable for something, even if like that would still freeze the next guy who goes, okay, they may not impeach me for it, but they've just shown that they can come after me.
It would only be for the one person because it would be for the person.
Because if you're saying the impeachment, you go, well, no, if they impeach me first, then they can get me on that. Because I don't think that doesn't. I don't feel like that follows properly. That goes, if I impeach you, now suddenly all your immunities are gone.
Okay.
Like
All
now
right,
suddenly
we
I can
might
get you for
disagree.
anything. Because that feels like, well, do you believe it removes all immunity? So something like even like civil, could they come after you civilly then go like, hey, we've impeached you, so now I can get, like your civil immunity's gone?
Well, the civil immunities would only be with respect to the office of the president in the first place.
But
So you would no
this
longer,
criminal one
no longer
applies
have a
the same
basis
thing.
to civilly sue him anyway.
The civil one, the civil immunity, this new criminal is just expanding basically the current civil to the criminal. So they're saying they're saying so that if it removes the criminal, why would it not remove the civil?
I'm not sure there would be any ongoing civil liability because he's no longer in the office to have civil liability.
But now there would mean unless your criminal behavior happened after the impeachment, but if you do it before the impeachment, you're saying then it would still apply. Do you see what I'm saying? It just says I think because It would just be saying, I don't think impeaching you removes any of your anything besides just removing you from office and barring you from it. I don't think it does anything else. I think that's what he's saying. He goes, you're nevertheless affected. Like it doesn't insulate you either. It neither insulates you nor disqualifies you from anything. At least that's how I'm
Okay, so
reading it.
let me ask the question back because I'm not quite sure what we're disagreeing about. So, assuming the president is in fact impeached and convicted, to what extent do you think, under that circumstance, the president would have criminal liability for actions that were either core or official acts?
Nothing. There would be no implication whatsoever on what you could or couldn't be
Yes.
charged for at all. It
Agreed.
has no bearing on it. It shouldn't have any bearing originally just in the original reading, but just for extra clarification, the framers added, because the language of an impeachment is so similar to a criminal trial, just to be safe, they added, nevertheless, you're still liable to all other forms of criminal law. Even if you were, quote unquote, convicted in the Senate, all the conviction does, as it says in the beginning, it shall not extend further than to the removal from office.
Yeah, it's a political remedy.
Yeah,
Yeah,
it's only
so that
political
you
remedy.
can't-
However,
it has
if you
no
are,
implication.
quote unquote, convicted, okay, nevertheless, you are liable under all criminal law, regardless of this
Yeah.
conviction, right? But it doesn't
Yeah.
You
mean,
don't get
but
double-
there's
you don't get
no,
double
there's no reverse reading here where it's like, well, if you're not impeached, now you're not liable for anything.
Well,
There's not.
Yeah,
Like the president deciding to pardon someone is a political act that obviously has legal consequence. It just happens to go the other way. So the idea of a political act, and the pardon only applies to the person pardoned. It's not a global thing, unless of course it is under its own terms. But if it's just to a person, then it's a political act but has legal repercussions. So I'm trying to say that with respect to Congress, it's the other way around. It's the political act of removing him. But it exposes him to the criminal possibilities he wouldn't otherwise be exposed to.
There's nothing
because
but that is
stripping of the immunity.
Yeah, but that everything
If you
you've read.
disagree with me, you disagree with me.
Well,
So I
sure, but
understand.
just to be clear, you can't source that from any part of the historical tradition. You can't source that from any part of the text. You can't source that from any prior Supreme Court opinion ever. That's just completely fabricated. That this is stripping some immunity that he had before. The only immunity that's being addressed here is the immunity from double jeopardy. That's it. And there's no reason to believe that anything else is being mentioned here.
That's what I see as well.
I think.
Fair enough.
Man, do you mind if I ask you about another recent Supreme Court case, or?
Sure, maybe, but if I haven't read it, I'm not going to.
If you don't want, obviously, I'm not saying like you're bind yourself to me now. I'm not going to tell you until you read. No.
Oh, sure.
The
Is it
Anderson
about
case.
The which one?
Anderson. That's the Colorado removing him from the ballot.
Oh yeah, I remember. Yes.
How do you feel? Because I was watching some of your coverage of it. I didn't finish it. Do you still stand by? Do you agree or disagree with that decision?
I don't. I feel like it's a bad reading of how the United States electoral system works. I don't understand that some of the language used in that was just so unimaginably bizarre to me. I think that the statement that I remember that was the most bizarre statement of that entire ruling was the idea, I think it's in the majority opinion, the idea that if we were to allow this opinion to hold or whatever, that we would be creating okay. Indeed, in some states, unlike Colorado or Maine, where the Secretary of State recently issued an order excluding President Trump from the primary ballot, procedures for excluding an ineligible candidate from the ballot may not exist at all. The result could well be that a single candidate would be declared ineligible in some states, but not others, based on the same conduct and perhaps even the same factual record. The patchwork that would likely result from state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole.
What's wrong with that?
It's dead wrong. There is no national guideline on how an election should be held. States are given absolute sovereignty over how they hold their elections. And there is a patchwork. Which part of that do you not agree with?
You can't. So, what is the case? You can't create new qualifications for president. So they can't say like, I don't care what this. Like, so all the states can't say you have to be 40 to be elected president, because that means you've defied the Constitution. Because now the Constitution's wrong. Because you can't. The requirement isn't 35 anymore. That's a lie. It's 40, because no state will put you on the ballot. You can't create new requirements for president.
Sure, you would incorporate the requirements of that. Sure, although nobody here is purporting to create a new requirement. They're purporting to get this requirement from the 14th Amendment, right?
So then here's the question. So either he's ineligible or he's not. And so if Colorado says he's eligible, like, is he eligible to be president? Yes or no?
Well, so the problem is this is a procedural question. How would you determine that? and there is no federal guideline on how that procedure should look. So every state has their own procedure for making this determination, like they do with every single other requirement listed on the requirement to run for president.
Do you believe they can remove people who are eligible? Can they say you are totally eligible to be president, but we're removing you for being ineligible because we just say so? Can they do that?
I imagine they would have to cite to something.
So, I mean, what I'm saying is, like, so if Colorado rules him ineligible, that doesn't mean that he's not eligible to be on the ballot. He's not eligible to be president, which means the end result cannot be that he's president. So if he's then sat by Congress, he was always eligible, and Colorado lied because he was eligible. You were wrong. You can't. At which point,
I don't know if that factual determination is ever made or compelled on a federal court onto the states. Like, for instance, I believe it's a requirement that the president is born in the United States, right?
Yeah, the natural born thing.
Yeah. Well, let's say that Donald Trump was more popular than he initially was in I think he did the birther thing was it 2012? With Sheriff Arpaio. Sure. Let's say that he managed to convince a lot of people Obama's not actually from the United States. He was born in Kenya, and some states decide, oh, okay, well, if you're not a natural-born citizen, yeah, we're not going to list you on the ballot. Why would the state not have the right to do that?
Because if they're wrong, you can't do that.
Wrong by whose determination?
Who sets? The Congress is the one that sets you as president. If Congress
Congress isn't making a factual determination that states must adhere to. There's no part of the Constitution that says that the state has to look to the federal government for a factual determination on any of these things. That's not listed anywhere.
They are the ones, if you are eligible or not. The eligibility, if the state says that someone who's 20 is 35, and all the states put him on the ballot, and it goes to Congress, and they go, he's not 35, we're taking him off. You lose.
But the states determine that, not Congress. Where is Congress?
They don't sit.
What?
They've not set people under they've sent people for the House and then they say, no, we're not sitting them under Article 3. You sent us someone ineligible. You can't if you send an ineligible person, you can give your electoral college votes to a goddamn rock. The rock's not going to be sat as president. I don't mean the rock, I mean a rock.
Sure, but then you would just waste your electoral votes?
Yes. So if you send someone who's 20 years old, they're not eligible to be president.
Sure, but you have the right to do that. Congress doesn't have the obligation to seat you.
Correct.
But the state has the right. But the state has the right to make that. The state has the right to make that determination.
They're determining, but the determination is whether you're eligible or not. You can only either you're eligible or you're not. There's no in between. It's not sort of you are, but you sort of aren't.
When you say whether you're eligible or not, but who determines the eligibility? It's up to the states to determine that. Whether it comports to the eligibility of the federal whatever regulations.
You can't change the situation, you can't alter what the Constitution says makes you eligible. So in the same sense where they go, I don't care that he's 20, we're still all sending him all the same. The Constitution's wrong. You can't just say the states have decided the Constitution's wrong. You can't do that.
No, but if the Constitution says you can seat somebody who is of a certain age, let's say that one state starts to list your age as a fetus as included in your age, and now somebody who's 34 years old wants to run for president, and let's say over half the states are now considering these types of people as being 35 years old, as long as you were fetal time 9 months or whatever, right? Well, that guy's 35. We count it. In Korea, they used to count birthdays that way. They used to count ages that way. By what process would Congress be allowed to tell a state, no, you can't list him on the ballots? We disagree with how you made that determination.
If Congress announces that so in terms of it's not a matter of you can't list. You can list whoever you want. Like I said, you can list someone who's ineligible. They just won't get sat.
Why can't you refuse to list somebody?
Because if Congress came out and said, yeah, that's totally like we follow the fetus thing in with a 35, like with the fetus thing. So he's 34 by whatever standards you guys think. But if he comes up to us, we're going to sit him, even though he's the same way. Why would someone remove him? He's eligible. He's eligible to be president. The state would be lying if they said he wasn't. He's eligible.
I think if you wanted to make this argument to me, I feel like I would need a source for this in law, because my understanding is that if the state wants to, the state could literally say, we don't even have elections. We're actually just going to send all of our electoral votes to alphabetical order.
Correct.
So why are we saying that a state is required by some federal statute to have their ballot done in a particular way?
So I'm saying because they're doing it under the authority of the Constitution. They're saying that we're removing you. We are enforcing Article 3 of the Constitution, and you're lying. You can't lie.
Yeah, but if they say we're enforcing Article 3, but let's say I don't know if that would do equal protections or not for
I know they're wrong. They're saying that we're wrong. Can they do it? They remove you from it. They just say we're wrong. So it turns out they will totally sit you for being black. But no, then they're not saying we won't remove you because you're black. They're saying we think you're ineligible because you're black.
I don't
They're
know
wrong.
I don't know the questions for like for equal protections as they apply to like I'm sorry, you're saying just because they're wrong?
Yeah, they're wrong.
I think the state would have the authority to do that. That's the state's power. That's the state's determination to make.
Ooh,
So they can
really?
get around any
Wow.
part of the Constitution by just being wrong.
It's your ballot. It's your state. States have plenary authority over how they hold their elections for federal office. I don't think the federal government has any input in there whatsoever.
They're not doing it via law.
They
You
have plenary
can't do
power
it-
to choose their electors, but having
Yes.
chosen a method, they still have to apply the principles of equal protection within the method.
And they can't. And again, like, they're not enforcing plenary authority. They're enforcing the Constitution. They're saying that you're not eligible under the Constitution. That's not their plenary authority because they're not.
Yeah, but how can you argue that a state doesn't have the right to be incorrect? How does God make that determination, or?
No, I'm
The
saying that the
Constitution in this
outcome is-
context.
The Constitution. If the Constitution
sets out the
says
criteria.
something
hold
and
on.
they go, I don't care. Like I'm going to enforce the Constitution and just say the wrong thing, then you're not enforcing the Constitution. You're lying.
Hold on. Yeah, but the problem is that prior to the 14th Amendment, it was pretty clear what these types of things were, right? Like, is somebody 35? No, what? It's not clear.
Article 3. They've sent people there and they've told them no. So there's states that have said this guy's totally eligible.
Wait.
and
What is
Congress has
Article
said, no, you're
3?
not. That is the whole you're not eligible because of insurrection. States have been wrong. States have sent someone who wasn't eligible, and then the Congress said no. They've sent back people. They've said no.
Wait,
So in the same
then
sense,
how does this?
if-
Hold on,
if
wait.
you try to say-
Stop. Wait, then
Sure.
doesn't that just support my argument then that a state could theoretically have somebody on a ballot that Congress would ultimately disagree should have been on the ballot, and then they would just send them back or refuse to seat them?
Yes, but the reverse is that they're not enforcing anything. That means they've sent someone pointlessly, but you're removing someone from the ballot eligible. You're saying that you are. It's the difference between saying we're not like we sent someone, it didn't work, we'll try someone else. But if you remove someone from the ballot under Article 3 and you're lying,
Yeah, but what is
have-
the procedure by which Congress would determine if a state was incorrect in how they created their ballot?
I would expect normally. So again, this isn't something that I would ever expect to come up in the same. That's why I go for the whole 35. It's never come up because it would be retarded for it to come up. I don't think they address the retarded.
No.
It's
Hold on.
going-
Wait. Stop. I agree with you that it would be quote unquote retarded for all of the criteria except for clearly for this one. It was more complicated, right? But the law being retarded or confusing doesn't just mean that you get to hand wave the law or say that, well, it doesn't apply in this particular way,
Correct.
right? But that's essentially what they did. They argued that, wow, this is really complicated, and it would result in a patchwork. That was the argument. They didn't say, well, we don't believe that this law is correct, or we don't believe that this law, would work out as intended or whatever. They're saying that, like, it would be really confusing and complicated, therefore we're just going to hand wave this, not law, by the way, part of a constitutional amendment, part of the Constitution.
It's saying that if you the follow through of saying, so let's say Colorado rules him ineligible and he actually becomes elects president and sat as president. Is he president? Yes or no?
If what?
If Colorado, let's say he gets every single vote except for Colorado. Colorado removed him for being ineligible to be president. He wasn't ineligible to be on the ballot.
Yeah.
He cannot be president. The end result is forbidden for him to be president.
Wait.
Every other state says yes,
I don't think
is he
Colorado.
president?
Wait. Colorado doesn't have the ability to say who can
They
or cannot be
ruled him
president.
ineligible to be president.
No,
not
stop.
ineligible to be on the ballot.
What? How do they rule somebody ineligible to be president? They don't even make rulings on that. They don't even have the authority to rule
Removed
it.
him
No, that's
for
the whole
that.
thing of the 14th
They
Amendment,
removed
right?
him.
The whole thing of the disqualification is that he's ineligible to be president.
They didn't remove him because they're saying we don't agree that he shouldn't be on the ballot. They're saying that the reason we removed you is because you're not eligible to be president.
Correct.
That was their
that's,
statement.
That's their
Right.
statement,
They-
and that's why they removed him from the ballot. But
Yes.
ultimately, because they don't want to waste their electoral votes, not because they think they can march on Congress and dictate that to them with their state guard. They're just saying that because we don't think he's
what
eligible.
he's asking is now you have one state, Colorado, in this hypothetical, you have one state who says this guy is categorically ineligible. He cannot be president. And you have 49 other states who have, with their electoral vote, said we want this guy to be president. And now it's before Congress.
Yeah.
And now what do we do? Because someone's is he
Colorado says he's
eligible or
eligible.
not?
Hold on,
eligible?
wait, hold on. You guys are making a problem that doesn't exist. I don't understand. Colorado has no right, has no jurisdiction to decide who's seated as a president of the United States. That's
exactly what the
That's
case
my
was
point.
about, though. That's the point.
They determined
But
him ineligible. They don't get to make that determination.
Yeah,
They're not determining
so-
whether he gets to be on the ballot. They're determining whether, because we're talking about Article 3 of the Constitution. Article 3 doesn't give a flying fuck what ballot you're on. It says whether you are eligible to be president. Can Colorado decide that he's not? I would say no, they can't.
No. Hold on. Colorado is not deciding if he's. They're not deciding on the criteria. The states are deciding if he fits the criteria listed out in the Constitution. Now, if states end up disagreeing between those things, that would be unfortunate and it would create a chaotic system. But the laws as written, that is exactly how the system is set up. If Colorado makes a determination that we don't think that this fits the criteria, then they don't list them on the ballot. But their authority to make that determination ends there. If Colorado thinks that he doesn't fit the criteria, Colorado can't sue another state. And the Supreme Court ruled this way, and they agreed when they shot down Texas's claim to want to dictate to Pennsylvania how their electoral system was run. They said, you don't have any authority there. You don't have standing to make that determination.
Maybe if we take it out Trump, maybe it'll be better. So, for example, John McCain was born in Panama. So if John McCain had gotten more votes, and some state had been he's not natural born because he wasn't born within the geographic United States. So he's not natural born. And one state had said that.
Yep.
What do we do now? Is that just okay, or is there any ability to review that? Because we're trying to determine what needs to be natural
hold
born
on.
or not.
There's tons of review, but the review is only in the state because the state has plenary authority. So you could challenge it in the state legislature. You could challenge the procedures in whatever the electoral procedure. You could challenge it all the way up to the state Supreme Court or the Court of Appeals of New York, whatever the fuck it's called. But the federal, there's no federal jurisdiction there.
Even though the provision that we're trying to interpret is in the federal constitution, because the thing that says that he has to be natural born is in the federal constitution, so it must necessarily be a federal law.
And either he is.
Hold on, wait. Just to be clear, you're saying that there is a federal law for how you have to set up your ballot in a state?
I'm saying that whether that's saying that the requirement that he's natural born is a federal law. Yeah.
Yeah, but there is no body. No, the federal government does not make that determination for the states.
It's a legal question for the federal government because it's a federal law.
They are the ones who determine if you're eligible or not.
They determine they determine if you're eligible for eligibility to be seated. It may be for the federal bodies, but the federal.
Is what Article 3 is about.
Yeah, hold on. Where in Article 3 does it say that the federal government shall communicate to states who they can list on their ballot?
Saying Article 3 is discussing whether you're eligible to be president. You either are or you aren't. There is no middle ground. There is no some people say you are, some are, no paradoxes. You can't both be under the age of 35 and over the age of 35 unless you're introducing supernatural. Are you?
I'm not disagreeing with
Maybe
you
it's
on
a
the
time zone thing.
I'm not disagreeing with you on the matter of fact. What I'm saying is that procedurally, there is no procedure which guarantees congruence between all 50 states. In fact, I could be wrong, but it wouldn't surprise me if it's somewhat common or if it's happened that sometimes there are presidential candidates listed in some states and not listed in others. That probably happens, no? Here's a question.
Sure.
Actually, was Kanye West listed officially on some ballots for the general and not on some ballots in others? That probably happens.
Yes.
Sure, but
With
they're not
respect
ruling on his
to the
eligibility.
ability, ballot access requirements, which arguably themselves are not constitutional, but that issue.
Whoa, hold on. So you're telling me that it's not constitutional?
It's an open question.
It's not an open question. States have plenary authority. They can list. They can choose whoever they want to list on a ballot. Are you saying that every single citizen in a state has the right to be on the ballot for an election?
Well,
No.
I mean, the Constitution sets out the criteria. This is U.S. term limits versus Thornton. Same idea. It's these are the exclusive criteria, and you can add no additional criteria.
Exactly.
So saying, prove that you have 50,000 people supporting you, it would be arguably an additional criteria. It might be unconstitutional.
Well, not only do I, just as a quick thing, not only do I disagree with your arguments, none of the arguments that you guys are making are made, I don't believe, in this ruling. And I did read this entire ruling. The arguments made are all pragmatic ones saying, if we did this, this would be really wacky. That's essentially the argument made. They don't make the argument. They're like, well, the federal government can tell the states what to do. They don't. What they do is they try to attack that criteria by doing a historical consultation of what insurrection meant, and then they attack the pragmatic implementation of it afterwards, saying that, well, this would be highly unpragmatic. None of them make this argument that you guys are making, that the federal government can dictate to states who goes on their ballot.
They can dictate what the federal law means.
There is no federal law dictating what goes on the ballot, though.
It's not about who's on the ballot.
The question is the proper interpretation of the 14th Amendment.
They're not
Their entire basis.
plenary authority.
Their entire basis was the 14th Amendment. That's a federal law. It's up to the federal government to say what that federal law means. What are you talking about?
What?
The 14th Amendment's a federal law.
First of all, the 14th Amendment is part of the Constitution. It's not a law.
Which is a federal law. It's the supreme law of the land. It says so right in the Constitution.
Doesn't the Constitution exist above the executive, the legislative, and the Supreme Court? I thought the Constitution is above all three of these things. It's not, if you pass
it's the supreme law. It's a law.
Okay.
So wait, for the 35 thing, if let's say someone's 40 years old, if Congress says, yeah, like I go, there's a question. One state wants to remove him and says, we're going to remove him because he's 20 years old. Congress, and he goes, he's ineligible because he's not at least 35.
Sure.
They're not saying that they're removing, they're just saying he's ineligible. Congress comes out and says, no, we'll sit him. Like, he's 40, we'll sit him. Can the state still remove him for being, he's eligible? He is. The statement is yes. Is he eligible under that rule? The answer is yes. How can they remove him and say, no, he's not? They just go, we're lying. We're just going to pretend that it's not true.
If we want, we can take like 15 minutes if we want. I'm not aware of any federal law or any part of the Constitution that points to the federal government being able to tell states who can or cannot be on their ballot.
I'm not talking about who's can be on the ballot. You're saying, like, you keep expanding it to
wait,
that.
Hold on. Wait. Okay, I'm sorry. Wait. Very clearly, okay, with using as few words as possible, with no analogies, no metaphors. What exactly are you saying the state does not have the right to do here?
Determine eligibility. Under the Constitution, you can Article 3.
We're not talking about. We're not talking about determining eligibility. We're talking about the process by which the state determines if the candidate comports with the eligibility. States could have a disagreement there. Is that possible? Yes.
I mean, if you allow for supernatural, yes.
Not for supernatural. If we allow for Section 3 of the 14th Amendment, where it says, hey, somebody who shall have engaged in insurrection or blah blah blah, there was a reasonable disagreement between states on that. Correct.
Say again?
There could be a reasonable minds could disagree on that eligibility criteria, right? They're not disagreeing on whether or not that eligibility criteria exists. They're disagreeing on what it means to satisfy that criteria. But there's no fact determinative way that any law sets out for the federal government to dictate to the states whether or not a candidate satisfies some eligibility criteria. No, that's up to the states to determine when they craft their ballots.
If all the states say someone isn't eligible and Congress says that they are, they are. If all the states say someone is eligible and Congress says they're not.
No analogies. Wait. Let's just deal with exactly what I just said. Okay, sure. A state could determine that this candidate is eligible, okay, because we think that he didn't engage in insurrection, okay? We see that eligibility criteria, but we don't think we went through our process, so we're listing him on the ballot. Another state could say, we agree with the exact same eligibility criteria. We're not challenging that, but we think that this candidate fails based on that eligibility criteria, so we're not going to list him on the ballot.
Who wins?
What do you mean, who wins?
He is or he isn't. Is he eligible or not? It can't be both.
Who determines that?
And the thing that's making him
ineligible... The issue you keep saying is he can't be both. Okay.
Correct.
Well, but the problem is each state is left to make that determination on whether or not to list him to the ballot, whether or not he comports with the eligibility criteria. The states are left to make that determination themselves. There is no.
Disagree with the whole, they can create new rules as to why someone's eligible.
It's a legal
No, I'm not saying they're making it. It's not.
They are. They're making a new rule because if he's made president, if someone says he's not 35 or he's not Article 3, and then he's sat, you added a requirement of yourself above and beyond what was necessary for the president. You added a new requirement.
You're not. You're just interpreting.
Feelings.
You're interpreting the requirement that's on the books. You're interpreting it. There is no there's no eligibility list handed down from Congress.
How do you determine if someone's eligible or not?
That's the whole point. The states do.
Will they be sat or not?
That's up to Congress.
The states can't say, it can't go, you know what, we decided you're not eligible if you're... They can't do that.
They do every single day when they create ballots. Let's say that I go to a state and I say, I want to be listed on the ballot. Here's my fucking birth certificate or whatever. Birth certificates aren't a federal matter. There's no federal jurisdiction on your birth certificate. But let's say that you say like, oh, whatever. And some guy looks at it, he's like, bullshit. This is fake as fuck. I'm not listing you on this ballot. I don't think you're 35 years old. You look like a fucking kid. There's no federal intervention in that argument whatsoever. I don't think you could appeal that to the federal government. The state would say, kick rocks. I don't believe in this birth certificate. They would go through that procedure, that process, and they would say, boom, you don't qualify. That's it.
Then you disagree with the Thor decision, saying that, states can add whatever requirements they want to make you president.
We're not...
It's
not talking about adding a requirement. It's talking about if you satisfy a requirement. And reasonable minds
can do whatever they want within that, right?
But not...
It's a legal question. In order to be present, you have to be this thing. That's a legal question. What does it mean to be that thing?
No, that's
It's
not
in the
illegal.
federal
Hold
law.
on. That is not a legal question. That's a procedural question. There's no legal definition of age. There's not even a legal definition, I don't think, of naturalized citizen.
There's no such thing as a procedural question. Procedure by its nature is process.
Wait, then
Yes,
You
hold
can
on,
have
no,
a
wait, wait.
factual question or you can have a legal question.
No, hold on. But the question of how do things show up on ballots that's a state procedure.
Yes, there's a process for
Yes.
it, but you're trying to a process in order to answer a question.
That's what happens in every single state already. How does a state know if
Yes,
you're
but-
35? How do they know that?
That's a great question, and that's a legal question.
It's an issue.
And how
don't
would you
get
make
into
that
because
determination?
Supernatural isn't real. Like,
Hold
it's
on.
just not
How
an
would you
issue
make that
run into.
determination? You might, for example, look at a birth certificate. So you're looking at a birth certificate,
Yeah.
which is a factual document to ultimately make the legal determination that this person's 35.
Okay,
I think
so
it's-
let
we've
me
had this
let's say
natural
let's say
born
that I
issue referring
take
to.
let's say that I give my son my birth certificate and I say go and tell him that you're that guy, okay? And he has the birth certificate. Is he allowed to say, "Oh, you have to list me on the ballot"?
Well, that's a question of fact. Does this birth certificate actually belong to this person? That's a
I
question
agree.
of fact.
That is a question of fact. And who has the authority to investigate that fact?
As to the facts,
Yes.
I would say that the states do. But
no,
if they
that's
make
exactly
the wrong
correct.
Just
legal
make
Wait,
something
how do you
up.
determine? No, wait. How do you determine if they make a wrong decision? You're saying the federal court has judicial review of the state factual determination?
with respect to the to the ultimate
Eligibility.
legal determination, they do.
Okay. Well,
So
if that
they-
was if that was
if
the
they-
case,
so if you had a state, for example, that
no, wait, we don't need an
was
example.
presented
No,
with
we don't need an
an-
example. If that was the case, then the Supreme Court would have just said that. In fact, this wouldn't have even made the Supreme Court. They would have just said like, oh no, the lower court said the federal government is just going to make this fact determination, and then boom, you're done. That's it. But
Legal
but the
determination.
federal government cannot make those factual determinations for how
Legal
the state should.
determination.
What?
Legal determination, not factual.
No, it's factual. Is it not?
No. It's a legal determination. Is he disqualified? Does he meet the criteria for disqualification? Is ultimately a legal question. Here's a whole bunch of things Trump allegedly did. Okay, it's ultimately reaching the legal question of does it satisfy this legal standard?
Even though you're saying legal here, I'm pretty sure that's a factual.
Well, how do we just so for natural born? Why doesn't everyone just get to like go on their own whims? Why is there actual? How do we get those requirements? What does it mean to be natural? There was a
The
court
states
case for that.
determine it.
On their own. Well, then why did one go to the Supreme Court? Why did the Supreme Court outline what it means if each state just gets to decide on their own whims?
No, hold on.
How could they do that?
Stop. Hold on. Wait. Distinguish what I'm saying. I'm not saying that the states can determine what natural born means. I'm saying that the states can determine what fact determines if you're natural born. That's what I'm saying. The state doesn't get to determine if you have to be natural born to be present, but they can make that determination on if you're a natural born. The states must make those determinations, and they do. When you get listed on the ballot, I'm sure different states have different requirements for how you get a driver's license or how you prove your age if you want to sign contracts. I'm sure every state has their own regulations and restrictions on that, correct? Now, they're not
Can you give me
saying
an
that...
example of ever happening? Okay, you example of someone like where they remove him from the ballot for being 30 and someone else kept him on for being 40.
Well, the thing is that...
You're saying that each one just decides on
hold
their own randomly.
Hold on. I agree with you that generally this doesn't happen, but that's
Not
because...
generally.
Well, I'm sure I
Absolutely.
could find one or two exceptions, but I'm not going to do that to you because it wouldn't be relevant. Your point still generally stands. But what I'm saying is that are there 3 or 4 different criteria for being listed on the ballot if you ignore this 14th Amendment? I think it's
You have to be
age.
35, natural born, lived in the United States for 14 years.
Yep.
And no Article 3.
And you can't be... wait, is
And
Article
you
3?
can't have served more than 10 years total.
Yeah. So those are the criteria. Now, generally for those, the facts are pretty easy to determine. It's not like it's hard to say if a reasonable mind will disagree on any of these particular things. However, if we are to assume that Section 3 added a new criteria, well, that's a new criteria listed that for the first time, reasonable minds could disagree. So I agree with you that on the 35 years old thing, seems to be that every single state would be in agreement for what a 35-year-old person is or what they look like. But for, have you engaged in insurrection or whatever, or aided and abetted in or whatever? Well, that's a more challenging question. That criteria is more challenging to determine. And for how you determine these fact-based things, it's always been left to the states. But generally, states are going to disagree on the age of a person.
Generally. I'm saying like I can't even find a single time where where someone was removed for being 20 and then sat as president for being 40.
Well, you have to consider that this would have to be a person that was popular enough to gain widespread support in the United States, was just on the edge of being 35 or 34, right? And that nobody else who was like raising serious questions. Like, there's a lot of criteria. Like, how many presidents have there been? Like 45 or whatever. Like, it's not like this is going to be a thing that comes up so often. So
that again, so that a state can actually remove anyone for any reason and just say that you're ineligible. And if they're wrong, that's just okay. So again, like they can remove someone for being black. Say you're under the age of 35 because you're black.
Like let's say, well, hold on, stop. I don't, no. I don't, the equal protection, I don't know how that works. Let's say it was this. Let's say that a state said, we're going to implement a new super real ID system. The way that the super real ID system works is to verify your age, somebody needed to be present at your time of birth. Otherwise, we don't know how old you are. Now, they go through this for some number of years. Now, let's say that somebody's running for president and they say, hey, look, I got a birth certificate. Look, it says I was born, in this age, blah, blah, blah. And then they look at you and go, okay, do you have the super real ID? Like, what do you mean? Well, who was your mother that was next to you? Who is here to attest to the time and day that you were born? You're like, well, I don't have anybody. And they say, oh, well, in that case, we can't make a factual determination of your age. We're not putting you on the ballot. They're not changing the criteria. Their way of determining that fact, though, is precluding somebody from meeting that criteria, so they wouldn't list you on the ballot. My understanding is a state would be 100% within their authority to do that, and the federal government would have no review of that decision. If the federal government did have the ability to review that decision, then this whole Supreme Court case would have been possibly tossed out, or at least one justice would have said, oh, well, if there was a confusing matter here, well, we could just have the federal government make the fact-based determination, and then all the states would be required to fall in line. But that's not what was argued by the majority opinion here, that, oh, well, this fact-based determination could be made by the federal government, because nobody seemed to have that opinion.
So then do you believe under the opinion that where Cenk was removed from the ballot because he's not a natural-born citizen, do you think that was wrong, that removing him from was wrong?
That was the factual determination that state made, but, and I would have donated a lot of money to Cenk to see him challenge that. Maybe that state wants to disagree with what that means. I don't know if that's been defined by federal law. I feel like it still hasn't, only because I hear Nazis make. Well, no,
it's saying that, like, even if he goes in and says, like, yeah, no, I'm not, but it's not for the state can't make the determination. Just like for the Article 3, you can't determine that I am not a natural-born citizen, even though I admit to it.
Wait, the state can't determine how do they know to list you on the ballot or not then?
So the thing is, right now, so I'm saying they can remove people who are under the age of 35. They can remove...
No other examples, just for this. Yeah, how does the state determine if you're a natural-born citizen or not?
If you fit the criteria, but again...
Wait, how do they determine if you fit the criteria?
And there's some dispute over that.
No, there's no dispute. The federal government has no review. There's no jurisdiction. They have no review of that. The state makes that determination. When?
No, that's the requirement to be natural born is in the federal constitution. Of course, the federal government has the ability to review that legal question. That doesn't make any sense.
You're determining eligibility. If Congress will sit you, you're eligible. Period. You can't be ruled ineligible.
They can have. How do they determine if you fit the criteria?
If Congress will sit you, if your Congress will sit you, you are eligible. Period. You can't say he's not.
Okay. What you're saying there, I don't think there's any way for the federal government to transmit that to the states. The federal government never, ever, there's no process. There's no rule. Why not?
When would they?
Why would you? Because if you have a disagreement on if somebody meets the eligibility.
You can't. If someone says they're 35, if someone like or what's his face, he comes in and says, I'm not a natural-born citizen. I want to be on. There's no one withstanding because either you are or you aren't. If you,
sure.
And he goes,
okay. I don't know if you're. I don't know.
Take remove from it.
I don't know if they. I don't know if they're. I've been giving you that, guys. Maybe. But what I'm saying is more. Let's say somebody comes up and they give you a birth certificate that's done in crayons, and this birth certificate says I'm 36 years old.
Sure.
It's ultimately up to the state to decide if they trust or don't trust that. The federal government has no review over the state.
But that would be a question of fact, whether or not that birth certificate is authentic, which incidentally could be the case for some birth certificates because not everyone's necessarily born in a hospital. Maybe all you have is is a document from a midwife, or maybe all you have is.
Let's even go with that.
But who's determining? Who's making that determination?
But that's a question of fact.
No, it's
whether or not that reflects.
Let's say the federal government says you're 35, and the state has its own the real ID thing that says you're not. You're eligible to be president because you can be sat as president. You aren't ineligible no matter what the state says. They can go, no, our thing says you're 40. It doesn't matter because you're ruling on his eligibility. You can be sat. You are eligible. You can be sat as president.
You keep mistaking the eligibility criteria with whether or not somebody satisfies the eligibility criteria. When the courts decided if Trump had engaged in insurrection, that was a statement of fact. That was what the fact that they found.
Or you didn't.
Bro, that's not how jurisdiction works. When you say either you did or you didn't, a different court can have a different finding. Courts do not make determinations that are true throughout the entirety of the universe as a physics law of nature. The court makes a fact determination that is valid for that court and that jurisdiction. But do you agree that a different court could find a fact differently in a different venue? Even with the exact same laws, a court could theoretically find the fact to be different, no?
And if you're wrong, the fact is that it means you added a requirement to the presidency, which you can't do.
Couldn't a reasonable mind disagree on some...
No! You can't disagree whether Congress will sit them or not. Either they will or they won't. You can't disagree.
So
determining eligibility.
Do you think that do you think Congress could add an eligibility? You cannot seat a president that is a giant fucking cockbag. That could be an eligibility that that Congress decides to have for the president of the United States. Now, if they make that eligibility, it's up to each and every state how they determine if the president is a giant cockbag. Different states could do fact-finding on that, and because there's no federal guidance, or maybe there's very little on the historical record, different states, reasonable minds could disagree when they do that fact-finding, as they did about Trump having engaged in insurrection. Colorado did a fact determination. They said he has engaged in insurrection. We agree with that. I believe a couple other states tried to rule on it, and they disagree. They said no, but they disagreed on those facts.
For that cockback thing, again, you can't add requirements to president.
No. I'm saying if Congress added it, a federal.
So like if they added an amendment, yeah.
Yes.
Well, then you would say then either he is or he isn't. Again, like I don't know what if they didn't define it properly enough, you can say that the states don't have the ability to determine it. But we have no idea.
But that was the issue because the definition in Section 3 was people thought it was kind of vague. What does it mean for having engaged in insurrection? There is no fucking definition for insurrection. That was
which is ultimately a legal question.
And find him not guilty.
You can say it's a legal question.
Yeah, but it's challenging to answer that legal question. But you wait.
That's why you asked the Supreme Court. The Supreme Court said, "Okay, here's what we're going to do."
But the Supreme Court didn't give us a definition for insurrection.
No, they didn't. They simply said the state had no power to adjudicate it, which was enough to get rid of the issue.
Yeah, but they didn't say that because the states aren't allowed to make their own factual determinations or whatever.
They literally did. They said the state is without power to adjudicate the issue.
Means they can't make it. And that's what they're doing. They're adjudicating and saying you are not eligible, and they can't decide that.
You keep using this phrase, determine you're not eligible.
Which is what Article 3 is.
To try to smuggle in that I'm saying they can change the eligibility requirements.
They would be.
I'm not saying that a state can tell you that the eligibility requirements are changing. I'm saying that it's the sole authority of the state to tell you if you meet those eligibility requirements. That's what I'm saying.
Either you meet them or you don't, and so therefore you can't have two states that disagree because one of them's wrong, one of them's lying.
Well, they have to be lying? If if two different courts analyze the same set of facts and they come to a different determination, that means one court is necessarily lying?
If Congress says that they'll sit him as president, therefore he is eligible, will sit him, which means he is eligible, and a state says, nah, we think he's not, they're lying.
We could just be wrong.
Wait. Or you mean reasonable minds between a federal court and a state court couldn't come to a disagreement on facts? Somebody must be wrong? You don't think that reasonable minds could disagree on a factual assessment between a federal court or multiple state courts?
Give me an example of this happening. Give me an example of someone, like I said, the 40-year-old, any one of us. I realize you're saying, like, I don't bring up a specific one. Give me a situation where we have removed someone for ineligibility to be president, and then they became president anyways. There isn't one. There isn't a single. If you can
Are
find
there
one,
any presidents who were
I
elected
couldn't find one.
who weren't listed on every single ballot? I have no. The thing is
That's
because of
not the position. It's not going to be based on because if you remove outside the whole Biden where it goes he won't appear because you have to. You're still eligible to be president, just you're not going to appear on the ballot. You do a write-in. But in the same sense, you go, if eligibility is based on whether you appear on the ballot. If I say I want to be on the 2016 ballot, you can't keep me off of it, but you can't do time travel. Like, that doesn't mean that I've been ruled ineligible. It's just time doesn't allow it.
What is this The last time that this happened was in 1964 when Lyndon B. Johnson was elected president without appearing on the ballot in Alabama. Due to infighting, the Democratic Party of the state refused to back electors pledged to Johnson as the national nominee, instead backing unpledged electors who backed Johnson's opponent, George Wallace. This is part of a larger campaign by Wallace, according to reporting from the Time.
Yep. That doesn't say they didn't remove him. They didn't go like he's ineligible. You could still vote for him. There's the whole thing with, what is it, Alabama that's doing that? I don't know if that, but for Biden.
They just said that, wait, what the
fuck?
fuck would be the point of voting for him if none of the electors are going to be pledged towards that way? What do you...
The electors, again, you're going back and forth between ineligibility and the plenary authority of the state to assign their electors. They can assign their electors, but they can't say that they're not assigning it based on ineligibility when they can't make that determination.
I'm just not aware of what, like, I would ask in law, like, where do we source this? Like, where are we getting this from?
The Constitution?
Wait, sure, okay. What article, what clause?
The one that we're talking about that says the requirements for the president shall be 35, 14 years resident.
Because why doesn't it just say, like,
born.
you're 35 if the states feel like it? Like, do whatever the fuck you guys want. Like, it doesn't say that. Why would it even put the 35? If everyone can just make up their own rules for it, for 35, and just go, I've decided that we do dog years now, so 5-year-olds can do it. They'd still be meeting the criteria of saying you're 35. They're just saying it happens in 5. The requirements would serve no purpose if each state got to independently determine what meets those criteria. The criteria has to be stagnant. There can only be either you are or you are not eligible. I'm not saying you can't remove them from the ballot due to, like, timing things or, like, again, going like, I can't put you on a 2016 ballot. I'm saying that if the state says, I am removing you due to your ineligibility for not being 35 or not being a natural born citizen, that can only have one answer. It can't have 50, which is what the Supreme Court was saying. And this is the only time this has never fucking happened before, where a state is trying to independently determine it. And if he sat as president,
okay, so we're just diving straight to the Constitution, okay?
Sure.
Okay. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations except as to the places of choosing senators.
Okay.
Man,
so time, place, and manner is up to state. Okay. So they can choose what date, where. Sure. Okay, fine.
Wait. Wrong section. Legislative branch.
And they can choose the manner of voting. So it could be a ballot. Could be show up in a room and go walk to the right side of the room. I don't know. Whatever. Yeah, that'd be fun. Hand count.
Wait, hold on.
Who shouts loud enough?
President, election, Constitution. Election, Constitution, Article 2. Hold on. That was for Congress. 1 second. Okay, Article 2, Section 1, Clause 5. We'll just read through this part. The executive power shall be vested in a president of the United States of America. He shall hold his office during the term of 4 years, and again the vice president. Each state shall appoint, in a manner as the legislature thereof may direct, a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. Okay, so this says that the manner, in such a manner as the legislature thereof may direct, okay, the electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. Has this been changed?
Yeah.
Wait.
No. So the president and vice president, as a practical matter, need to be.
Oh, I'm sorry. That's for the vice president. Yeah, I gotcha. Not that's. I thought that was with according to the electors. Okay. And they shall make a list of all the persons voted for and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the president of the Senate. The president of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates and the votes shall be counted. The percent of a greater number of votes shall be president, and a number of the majority of the whole blah 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 blah. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States.
Yep. So natural born, 35 years old, have to have lived here 14
Where
years.
does any
Yep.
part of this say that the federal government or that Congress is making fact determinations for how states are listing people on their ballots? Where does it even mention how they
keep
do
going
their
to the
ballot?
ballot thing, man? I don't know why you keep doing that.
These
Like
are
I've straight
these
up
are
said to you,
these
there
are
times
these are
where they have
ultimately
put
legal
people
questions.
on the ballot who are ineligible. You can do that. They have sent them to Congress. If the state says yes, this person's eligible, how come Congress cannot sit them under the same rule, saying you're not eligible?
Because
Right,
because
so-
wait
Congress-
because they could have a
you just-
disagreement
you
there, but
just
it's
read
wait
legal language.
because they could have a disagreement there, but ultimately Congress is the one sitting the representative.
Bingo.
What?
That's exactly what I'm saying. You can't disagree with Congress, and I don't care if the state thinks they are or aren't. They
You
don't
didn't
disagree.
say that. You didn't just say that you can't disagree with Congress. What you said was that
I
a
just
state
did.
can't force Congress to seat somebody. It sounds like
I'm
the
saying
state
that
can
the
disagree with
state-
Congress. Wait, you even gave examples in the past where the states would vote for people that would go to Congress and Congress wouldn't seat them. So it sounds like the states can disagree with Congress, no?
No, because disagreeing would mean that they are actually part of the government, and they're not. They
Wait,
weren't
no, that's
eligible.
not what
You
it...
can-
Wait, a disagreement on
I don't
fact
care what the
is...
state says, is my position. If Congress says someone's not eligible, they aren't, no matter what the states say. The states can say they can have every single ruling, every single Supreme Court, every single one could say that person is 35 or older. All of them could agree on it, and Congress could still say no. If the states are the ones who get to determine whether you meet the criteria, how come they can, then why is Congress saying no? What right do they have to say no? They're not the ones who determine it, states are. The states all said yes, Congress says no, they won't sit him. But he was eligible. How come they're not sitting him? They're saying he's ineligible. They won't sit him. All the states, 50 states concurrently, all say the guy's 40 years old.
Yeah, wait, I
Congress
don't
says he's
disagree with
30,
any
won't
of
sit him.
this. But like, so for instance, Congress
states-
might think that we could seat this new president, but maybe 10 states disagree and they don't list him on the ballot. The states have the ability to do that. That's all I'm saying.
But then that's the whole thing with Thornton saying you can't you're adding a criteria that didn't exist. Because if Congress is saying that they would sit him, that means he is eligible, and you have added an additional criteria above that saying he may have met Congress's threshold for being sat, but he hasn't met ours.
Okay.
And you can't. It means you're
I could
disagreeing. It means you're
I could try to reread this whole opinion, but what you're saying here implies that there is a process by which the federal government is doing a fact determination that it is transmitting to the states somehow.
A legal
No, I'm
determination.
saying it doesn't have to. That's what I'm saying. Like that, this is so bizarre. It was never even fucking thought of that this would happen. That's why we don't bring it up. That's why you don't go like, well, do we have any time mages that can really give us this whole 35 thing? We don't do
Time
it.
mage,
Why do you think it's never come up? Why do you think it's never come up that someone's gone, here's someone who's 40 and the Congress has never said 20? If it's just like, well, no one makes a determination. If Congress never tells the states how old someone is, we should have error. There should be times where it doesn't match up. Or if the natural born citizen, there should be times where it doesn't match up.
I don't know
The
if,
one
hold
time
on,
where we
excuse,
weren't
wait.
certain,
I don't
went to
know,
Supreme
wait,
Court.
no, wait. I don't know if it ever would match up. Keep in mind that we have a two-party system where both parties are highly incentivized to nominate somebody that can run for and be elected president of the United States.
Yes.
Is it reasonable that we would expect at some point that parties would nominate an individual who might not actually be 35 years old because of a undetermined fact around like a birth certificate? It's probably pretty
They've
reasonable
done
to
it under
assume
Article
that.
3.
What?
They have said this person is eligible. They have ruled him ineligible. They have signed him. They have
Wait,
voted
not for
him.
president
They've
of the
sent him to
United
office.
States. I'm talking for.
Yep. You're
Wait.
correct. For president, you're right. This is the worst time ever, kind of thing.
Sure. So I can understand people maybe fucking up on representatives, but for president, this again, two-party system, entirety of the United States. I imagine they're
Why did
probably
we fuck up
choosing
on
people.
representatives.
What?
Why did we fuck up? Why is it that like goes? Because you go, wait, how did we get all the way to sending you there? It's because they had no idea what the fuck was going on. They go like, so I doubt they knew until the guy got there. They goes, wait, you sent him over? He's not eligible. They didn't like go like, we see it, and we're gonna secretly not tell you that you're not. You're saying
Okay,
the
so
wrong
then I guess
person.
like running over this one more time. So
Sure.
Section 3 says if you've engaged in insurrection, okay, that's part of the eligibility criteria. You're not allowed to be listed on the ballot. Okay, multiple
Yep.
states.
No. Not you can be listed on the ballot. You're not eligible to be sat as president.
Yeah, not eligible to be sat as president, okay? Or not eligible to be president,
Mhm.
okay? So multiple states take a look at this, and they disagree on what it means to satisfy that eligibility.
Yes.
And so
What I
some
would
people are
expect and
listed
what
on the
frust-
ballot. Hold on. Some people are listed on the ballot, and then some people aren't listed on the ballot.
which I would say you can't do. But yeah, go.
When you say, okay, now you say when you say you can't do that, you
Yes.
can't do that. How? What stops you from doing that?
You can't remove people for ineligibility when they are eligible.
Wait. Why are you? Who determines that eligibility?
Congress.
When?
We've never had to run into that issue before. The thing is, but they are the ones who determine it. Like we've had. Like
Yes,
when
but
we've
I'm
run into
asking
this issue-
when they list them on the ballot, they do the election. When does Congress make that determination that if states disagree, Congress is telling them, the federal government is saying like, oh wait, you guys are wrong on that.
If they decide that they will or will not sit them, whenever they know that, that is when they've made that determination. And that if there's a disagreement between the state and Congress, Congress trumps them. Do you think the states can trump them?
Yes, I think the state is allowed to.
Then how come?
Wow.
Then how did they remove him for Article 3? Why, like for the representative, how they go? We said he is eligible to be sat. Congress says you're not. How did Congress overrule them if the state is the one who determines it?
They can still both disagree, but
So
ultimately,
they can both say.
yes.
Someone has who has the right to make the decision, because you're saying that like
Stop!
they can't say
It's,
yes, but they
you're
can say
asking
no.
about a disagreement of fact, and you're confusing that with a disagreement of jurisdiction. The court ultimately gets to decide, or Congress gets to decide who they seat, but a state could still disagree that they have the right to seat
That's
them.
what Article 3 is about. Article 3 is about seating. It's about eligibility. It's not about appearing on a ballot.
Which, okay, give me, what am I, okay. Constitution.
Look at Article 3. It doesn't say, like, Colorado doesn't have to put these people on the ballot. Feel like it. Like, it has nothing to do with ballots. It's irrelevant. The ballot is wholly irrelevant. That's why you don't have to appear on a ballot. You can write someone's name in. It's about removing them from ineligibility. We've had cases before for 35 to try and stop someone. They go, a state has an interest in not putting people on the ballot who are not eligible.
It seems under your view, Destiny, that if the state wanted to, they could just not put a person on the ballot just because they don't want to.
Yep.
So, if the state of Alabama said we're never going to put a Democrat on our ballot,
well, no, it's not.
There would be no
that's
redress.
True. Yes,
Yes,
correct.
I believe they can.
They don't have.
Correct.
Yes, I agree. They don't have to put you on the ballot. However, if that isn't what Colorado did. They didn't just not put him on the ballot. They said you have to just get rid of any votes from. They're saying he's not. They ruled him ineligible. If all they said was people with the last name T don't appear on the ballot, I don't know if there's some other rule, but in terms of Article 3, there's no problem. It has nothing to do with ballots. It has to do with eligibility. That's why the whole thing recently with Biden, where he might
it would
not
be an
appear
equal
on some
protection
ballot.
problem.
Yeah, but that's not an eligibility thing. The eligibility is the issue we're dealing with. If they were just saying we're removing him from the ballot because fuck Trump, I would be like, fuck yeah, they can do that. It's their choice, plenary authority. They don't have to put him on the ballot, and they can say fuck Trump. That's I don't know. Actually, no, I don't know if there's some other rule, but I would have no issue with it. The issue I have is the reason why they're citing. They're not citing their plenary authority. They're citing the Constitution. They're ruling him ineligible when he is. And I'm saying that they're lying. They're not the answer. They don't determine. And then again, it's not up to them, because if Congress will sit him, that means you can't remove him because he can be sat. He's eligible. The answer is yes, he's eligible. So you can't say no, he's not when he is. If they can do other rules. They can remove him from the ballot. They can say time and place, all that stuff. They don't have to put him on the ballot. They can't say that he's ineligible under Article 3. Same thing with the 35. If someone was 40 and they tried to say, well, no, we declare you not, that would go to the Supreme Court, and the Supreme Court would go, no, you can't remove him. He's 40. The same thing, that's what we did with natural born, is they tried to decide, we had to figure out what the fuck does it mean to be natural born, because everyone was up in the air until someone challenged it, and that's why it's been laid out specifically. There's disagreements on really what natural born really means. The Supreme Court had to decide that.
Here's a question then. Why,
Sure.
if this is the case, then why didn't the Supreme Court just do a fact-finding thing and determine whether or not he had engaged in insurrection, and then just transmit that to the states?
Tons of attorneys have said the exact same thing. That's what they did for natural born. They determined exactly what that means, and they didn't do it for this. But I mean, that matches the previous thing. This decision, like I said, it doesn't give them enough detail, but it's the exact same fucking criticism I have for this whole recent one, is they're not giving the details that would fucking tell us the real answer. Which is also what the dissent is punting on and saying, what the fuck is wrong with you guys? You guys aren't giving us the information. That's why the dissent, even in this very recent, the fucking case we were just talking about, they don't give information, which leaves a gap, and we're sitting here debating, well, what does it really mean? They just kind of punt it. And the dissents in both cases both go, motherfucker, you're punting. Why are you punting? They're finding an excuse to punt it, and so they are. But we're going to have to
Wait, when you say
come to
punt,
it.
what does punt mean to you?
As in that they're not answering a question, so for the dissenting, I guess, yeah, punt.
I'm sorry, hold on. I don't want to reread this whole thing. Oh wait, this is a short decision. Wait, was it short? Was it really 20 pages? Oh, this might have been really short. I don't think they punted this. I think they solved it.
They're not deciding. Well, if they
I think they
solved it,
did decide it. I think they basically said you guys don't have the right to enforce this part of the Constitution. I think that's essentially what they said.
Okay, then how do they? But Cenk just got removed from a ballot for not being eligible for being natural born, and the Supreme Court won't. And like it was fine. No, like we're still doing the whole 35 thing. We're still not letting people over. All those things should be overturned, right? Because they're saying you can't make this thing can't make the determination.
No, they're just saying they can't do Section 3, but they left everything else the same.
Limit it to only?
What?
Hang on, I'd have to reread. Like I don't recall them. Did they distinguish this and say Article 3 is different from the other requirements?
I think they did.
If you did, then maybe again, actually correct. Like then you'd win instantly if you can find me that. I don't recall them distinguishing it. I mean, I remember them. They talk about Article 3 because that's what it's about, but they don't say like. But it is. It's the thing is, it's on the requirement. It's another one of the requirements. I don't recall them saying this requirement is special.
It is. I think it was special. That's why it was. That's why one of the reasons why I had so much issue with it, because it seemed like they were treating this fundamentally different than every other criteria that was given in the Constitution.
I will fucking concede immediately if like that's what they're saying. Then you go like, then fuck. I mean, I don't think. Then I would be saying I disagree with it, and then that would be the rule, and it would be fully decided. Yeah, I will concede immediately. But I don't recall seeing that. If you can. If anyone else remembers it. But again, I mean, one thing I'm seeing in chat, everyone's confused when you go disagree. Every single court case, every single one has attorneys disagreeing. That's literally what court cases are. The idea that goes, how can an attorney disagree with that? There's an attorney who disagrees with every single court case. That's why court cases exist. If everyone agreed, there'd be no lawyers. Like, I've never understood this thing. Like, where even like people who like shit on like Pisco and go like, well, it's a 9-0 decision. Are you right and they're wrong? The answer is, well, yeah, he could be. That's why we overturn decisions as well. Like, that's what attorney's job is, to argue.
Oh wait, hold on. I think I might remember this. I think that the ruling came from the majority saying that the only way that the states were allowed to enforce this criteria is if there was a federal court case declaring that somebody had engaged in insurrection. Or, I'm sorry, that
the impeachment thing. That's what my thought.
No, not the impeachment. It was that that Congress had to make legislation or something barring them, because Section 5 of the 14th Amendment mentions that Congress can make legislation.
Yeah, they argued that you had to be like there had to be some federal that you were guilty for them to find it.
Yeah, so in Section 5 of the 14th Amendment, it said the Congress shall have the power to enforce by appropriate legislation the provisions of this article. I think their entire argument came down to the fact that since Congress hasn't made legislation, we're going to say Section 3 doesn't exist or apply. So they essentially, this whole criteria is now
power by doing that. Yeah.
No, they didn't limit Congress's power. They
because Congress, because again, like, so for the the state thing, the Congress is the one who actually like Congress has, like I said, has said no to people. They didn't have some grand finding. They're saying for president only you have to do this, because the other alternative is actually, I think I forgot to mention, states do in fact remove people from ballots and say under Article 3 remove them for state, so that you can that the state can go, nope, you're not eligible under Article 3. You're off the state ballot. You can't become governor.
So per curiam, a group of Colorado voters contends that Section 3 of the 14th Amendment to the Constitution prohibits former President Donald J. Trump, who seeks the presidential nomination of the Republican Party in this year's election, from becoming president again. The Colorado Supreme Court agreed with that contention and ordered the Colorado Secretary of State to exclude the former president from the Republican primary ballot in the state and to disregard any write-in votes that Colorado voters might cast for him. Former President Trump challenges that decision on several grounds, because the Constitution makes Congress, rather than the states, responsible for enforcing Section 3 against federal office holders and candidates. We reverse. So the implication here is that all criteria are enforced by the states, but because the Constitution makes Congress, rather than the states, responsible for enforcing Section 3 against federal office holders and candidates, we reverse. So their whole ruling here was based on treating this in a different way than every other criteria that was set out.
It's based, like I said, where the whole thing, because we allow states, because up until now, it's been kind of a rule your own house kind of shit, so that a state has because the state is the only one to prevent you from holding state office, so they can enforce Article 3 there, but they have no power to do it. But for the House and Senate, Congress has been the one in charge. For president, there is no house to, the only house to rule that is Congress. Do you think this ruling is saying that you can do it for the 35? Because I would say that the same thing applies. You can't enforce the requirements. You can enforce the requirements on state.
No, I think a state could say, we don't believe that you're 35 years old, and then the state would be the state would make that. So, for instance, when Cenk was ruled as not being a natural born citizen, if he says, "Oh, well, actually, I am," the state makes the final determination of that. That's it. There is no federal oversight. There's no federal review.
He doesn't deny it. There's no for that. You either for all the other ones You either have standing or you don't. So like for that, he admits he's not natural born. His argument was you don't get to, even though I say it's true, you don't get to. They go, well, no, there's no argument. You say you're not, therefore you're out. If you don't even argue that you are those things, and I've never, like I said, I've never seen a case where someone argues that they are like 40. The state says you're 20. The federal government says they are 40, but we still said you can remove them from the ballot. We've never, like, this is so a unique thing that's never run into, and I get like why it's weird, and like because it's so bizarre. We've
okay,
never,
then maybe,
so
yeah, if he didn't, yeah, sure, maybe he didn't admit that, but
the ruling is because we've had people removed for 35, and they say the state has an interest in not having on the ballot and not giving their electoral college votes to someone who is not eligible because you're wasting your votes. But if the person's eligible, if Congress will
wait, I don't think everything you're
not
talking
wasting
about
your
is just a matter of procedure. I don't think any of this is like a legal, like the state can list whoever they want on the ballot. They don't have to justify it as long as it comports with the state constitution.
No, but if you remove someone for ineligibility, they have to be ineligible because the interest you have, the reason why you can being ineligible under the Constitution is because you have an interest in not giving your votes to your electoral college votes to someone who isn't eligible, who can't be sat. But Congress.
Wait, what is this? What was this ruled by? What are we talking about here?
It was the 30. Oh my God, what was the case? I forgot it. There was a few of them that I had to look for them. But it had to do with whether or not you could remove someone for 35, and someone tried to challenge it, and they said, well, it's not up to you, and they go, the state has a right to remove you because they have an interest in not having people on the ballot who aren't eligible.
And you said this went to the U.S. Supreme Court?
I don't recall that one. The one for
because that sounds like, again, I didn't know. I don't think that the Supreme Court like has review.
Natural born citizen was the Supreme Court one. Well, no, it's the Constitution. Why would they not have jurisdiction over the Constitution?
Wait. Does the Constitution require states to list every eligible candidate on the ballot?
No, it's saying that because if you go, we won't give our votes to someone who's ineligible, and we find that because under the Constitution, now you're enforcing the Constitution. You go, well, you're not eligible under the Constitution, so we won't give our votes to you at all. You are enforcing the Constitution, and they have an interest in doing that because if you're not eligible, you've given your electoral college votes to someone that once they go to Congress won't get sat. So it goes, so you have an interest in not wasting, putting people on the ballot or giving your electoral college vote. Colorado did. It wasn't just don't put him on the ballot. It was that and get rid of and ignore any votes for him. To say that because they were ruling saying he's not eligible under that same thing. We have an interest in not giving our votes to someone who can't be sat as president. But if he can be sat as president.
Okay. Just to summarize then, so this, so for this particular ruling, my original point was that states do have the ability to do their own fact determinative things to figure out if somebody meets a criteria or not, and they might even disagree with each other on that particular thing. This Colorado thing went to the Supreme Court. The Supreme Court did not engage in fact finding. Instead, the Supreme Court didn't say that reasonable minds could disagree. Instead, the state court said that Section 5 power, that's not enforceable by the states, and Congress has to make legislation for that. They took that completely away from the states, and they just removed that criteria from the states rather than saying that you have to... No, exactly. They said that only...
If they did that, if Congress went through that thing, found him guilty, and said, yes, he's not eligible, states can remove him. He's not eligible. And they have an interest in removing ineligible people, and he's been ruled ineligible.
Yes, but I'm saying that Section 3...
That goes against yours.
Well, no, because the original argument was whether or not this criteria was like every other one, and you said, well, is Section 3 treated special? And the answer is yes, it is treated special. That's the only criteria that requires enactment from Congress to enforce that criteria. Every other criteria is just done procedurally at the state level. We've never had a challenge. What do you mean?
Every single time it's been challenged, like for natural born, that went to the Supreme Court. Has anyone ever challenged whether I'm 35 or not? That's never gone. We've never had that issue. Same thing with when each time we've had one where it's natural born has gone to the Supreme Court. Now this one has gone. These ones are where it goes. What does it really mean? 35. We've never had that dispute. If we had a true challenge to say, am I 35 or not? I suspect that would have to go to the Supreme Court, and the Supreme Court would have to make a determination as to how do we actually determine you're 35.
No,
we don't have
no.
You don't think so?
No, the Supreme Court wouldn't have to worry about that. The Supreme Court did not reject this. I'm sorry. The Supreme Court did not reject the criteria because the Supreme Court said that all criteria are either fact determined by Congress or have to have legislation from Congress. They said that this specific one in the 14th Amendment does, because Section 5 in the 14th Amendment references passing legislation for this entire amendment if Congress wants to do so. But that criteria isn't.
It only applies to one, like, because it doesn't. Because remember,
No, wait. This doesn't apply just to one person. This applies to all office holders, I think.
I don't think so, because we've been doing it this whole time without challenge. Like we've done this before. Like we've been doing this going forward and without challenge.
No, it said it in the initial, because the Constitution makes Congress rather than the states responsible for enforcing Section 3 against federal office holders and candidates. We reverse. This is for, yeah. So this doesn't have anything to do with eligibility. It has to do with enforcement.
And because my understanding, because the thing is, I thought they referenced in it that we literally do this, like, because both state and federal office holders and candidates. Wait, scroll back up.
Wait, okay, so for this part, the case raises the question whether the states, in addition to Congress, may also enforce Section 3. We conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. So it sounds like they could enforce Section 3 for their own states?
Yes, they can. They do.
Okay, so that, and reasonable minds could disagree there. So in one state, a candidate who engaged in the exact same behavior, then another state might disagree. And one can hold office and one can't.
State has the power to go to another state, but yeah.
In our federal system, the national government possesses only limited powers, and the states and the people retain the remainder. Among those retained powers is the power of a state to order the processes of its own governance. In particular, the states enjoy sovereign power to prescribe the qualifications of their own officers and the manner of their election, free from external interference, except so far as plainly provided by the Constitution of the United States. Although the 14th Amendment restricts state power, nothing in it plainly withdraws from the states this traditional authority. And after ratification of the 14th Amendment, states use this authority to disqualify state officers in accordance with state statutes. Such power over governance, however, does not extend to federal office holders and candidates. Because federal officers owe their existence and function to the United States, voice of the whole, blah, 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 powers over their election and qualifications must be specifically delegated to, rather than reserved by, the states. But I think this is only with respect to Section 3 of the 14th Amendment.
Yeah, but I'm saying, because that was already true, because that's what I'm saying, prior to this, we have already been holding to both the federal government has been disqualifying people even against the states for but we've never, for the states have been able to, without issue, take people out of their own state officials, because they're the only ones who can, like, there's no one else to do it. But I don't believe that they extended this to federal, because I think that where it's saying that, yeah, the states can't determine it for federal, but that's already what I've been saying. When it comes to president, though, the rule we've been under up until this point is kind of like rule your own house, and the executive branch doesn't have a house to be ruled, like, so Congress has to do it. But
I think up to this point, it's been left to the states to make a determination if you fit the criteria of everything until this criteria got challenged, because people started to disagree.
Well, that's what I'm saying, where it goes, because you won't run into the issue of the patchwork thing for state, because like I said, when they send a state official for a senator, if they say, yes, he's eligible, Congress says, no, you're not, then you're not. I don't think we've ever had a time where we've removed someone from the ballot and said, you're not eligible under Article 3, and so you can't take a federal position, and then that Congress goes, yeah, no, well, we totally would have sat you. We totally think you're eligible, but unfortunately the state told you no, so sorry about that. I don't think we've never had that happen.
True. Okay,
I think that's what I'm saying. Okay. I don't, because the answer is either yes or no.
Yeah, or sorry, give me your final word on this. I've already said way too fucking late. You guys kept me way too late on this. Go, give us, your final closing thoughts or anything? I love you.
No, I mean, like I said, just my view, I guess the final thought is just saying my view is you're either eligible or ineligible. If Congress says you're eligible, you are. If they say you're not, you're not. We've had that issue litigated before, and that's always been true. So we've never had a situation the reverse. And I don't think the state can overrule Congress. I think that's my final thought.
Okay. I love you. Be careful. Stay safe, okay?
Take it easy, man. Bye.
Bye. Okay, I love you guys. It's been fun. Fuck me. Be careful. Got him. Just for